Appellate side mentioning.
May I get your lordship kind leave to move on urgent motion, lordship, tomorrow? Lordship, urgency is that I have challenged the terms and condition of the tender, lordship. And the dropping of last date of submission of tender is day after tomorrow,
Mr.
lordship.
Paul, you should know that I am not giving any further interim relief in tender matters. But anyway, if you want to, what is
I
the
can
urgency?
try my-
What is the urgency?
Lordship, urgency is that I have challenged the terms and condition of the tender, lordship. And day after
No,
tomorrow,
why tomorrow?
lordship, day after tomorrow is the last date for submission of the tender, lordship. That is why this is urgent, lordship.
Yes, tomorrow, notice to the other
Much.
side.
Madam, may I have your lordship slip?
I can't hear you.
Madam, may I have your lordship slip to mention one matter, my lord? Well, I have filed.
I can't hear you. Speak clearly into the microphone.
Oh. Well, I have filed a motion, my lord, in the month of March 2023, my lord. My lord, challenging the order passed by the appellate authority under the Arms Act, rejecting my claim without the order has been passed without notice, nothing of this sort. So
What is the date of the order?
the date of the order is, my lord, 13th October 2022.
Yes, you can wait till June. Come back in June and mention, I will list it. Yes.
Your Lordship, in WPA number 23148 of 2023, I am praying for upgradation of the matter into the list. The urgency is that the petitioner is a chronic heart disease patient, and he
When did you file the writ petition?
Yes.
When did you file the writ petition? Come back in June. Yes, yes.
My lord, may I be permitted to mention three matters, my lord? They are similar matters. My lord, tender notice was issued by Purvo Medinipur Jila Parishad on 6th of January 2023, my lord. Petitioners participated and they were declared as successful. Accordingly, a work order was issued on 13th of February 2023, my lord. That has been terminated arbitrarily on 20th of April 2023, my lord. I have filed a writ petition of 2nd of May, my lord. They are threatening me to issue another, fresh.
15th notice to the other side.
Your
Yes.
Lordship, may I be allowed to mention a matter? Your Lordship,
Yes.
Your Lordship, this matter was mentioned on 27th of April. Your Lordship had fixed the matter for today, Your Lordship. However, the matter is not appearing in the list. The urgency in the matter is that, Your Lordship, on 31st of March 2023, Your Lordship was pleased to pass an order directing the Arunachal Pradesh Labour Department and the other respondents to pay a sum of rupees 4 crores plus amount. However, that amount has already been paid before the order was passed, but the said facts couldn't be placed before, Your Lordship.
You're for the respondent.
Your Lordship, I'm for
And
the
yours, the Arunachal Pradesh government.
Your Lordship, I have filed a review application and they have issued a contempt notice, Your Lordship. So I was praying if they might.
Yes, I can
be
keep
listed.
it next week, but last week must be warned. Yes, 15th notice to the other side.
Obliged, Your Lordship.
Lordship, you kindly to mention this matter, Lordship. Lordship, this is a new motion. Here, the petitioner is a disabled employee with more than 70% disability. He is an employee in a nationalized bank.
You're not giving me the facts, just the urgency,
on-
please.
The urgency is that the promotion of the employee has been stalled and
Last
he has
cause
been
of action?
on 30th May 2020, Your Lordship.
Yes, come back in June. Yes.
Grateful.
My lord, I seek leave to file this writ petition under AST number in view of grave urgency, my lord. My lord, the Child Welfare Committee, North Chobbish Pargona, has taken away a four-year-old boy from his mother and given custody to the mother-in-law, my lord. The child is not attending
Who
school.
are you? Who is the
My lord,
petitioner?
I am the mother of the child.
What is the last cause of action?
2nd May 2023, I have written representation to the
15th notice to the other side.
My lord, may I be permitted to mention one matter under the heading to be mentioned, my lord. It's a group 6 matter, my lord.
Yes, sir. It's not to be mentioned tomorrow, please.
My lord,
Yes.
I am mentioning, my lord, on urgent motion, my lord, the subdivisional magistrate, my lord, the subdivisional magistrate passed under section 10(3) of the West Bengal Highways Act, my lord, on 22nd April 2023. And I also filed, my lord, the 10(4) application on 25th April 2023. And my lord, I filed this writ application on 29th.
What is the urgency?
My lord, urgency is that, my lord, they started the my proceedings, my lord, under the provision of, my lord, West Bengal Unauthorized
Come back in
Occupants Act.
June. Come
My
back in
lord,
June.
unauthorized
No,
occupants
come back
act.
in June.
My lord,
Yes.
they decided the issue on West Bengal Highways Act.
Come back with better
But
facts.
I-
I can't understand. Yes, Mr. Dutt.
Milord, I am Milord mentioning a matter challenging an e-auction of a stressed asset, which is Milord to be held on 15th. Milord, I have filed the writ petition on 8th May, Milord,
15th?
15th of May.
Yes.
I have filed the writ petition on 8th.
No,
Milord.
who are you?
I am Milord, the constituent Milord, whose asset is going to be transferred. That loan stressed asset, Milord.
You're a bank.
No, I'm the
Then why are you saying
constituent.
constituent?
Milord, it's my asset, Milord, my stressed asset, which is being transferred from the bank to RCIL. Milord, your lordship had the
Assignment.
assignment. Now that your lordship was initially pleased to abstain, Milord, observe that there is no prejudice caused. But Milord, at that point of time, I must say, Milord, we could not assist your lordship.
So
properly.
this is a matter which already I have passed an interim order.
No, no, not in this matter. That is another matter. Milord, since your lordship had already expressed a view, I brought it to your lordship.
Yes, 15th. Notice to the other side. Please.
My lord,
Yes.
I'm
public,
mentioning a
public land has been enclosed.
No, no, Mr. Dutt, you have to give notice that it's going to be
Yes,
in the
yes,
list
yes.
on 15th.
My lord,
Yes.
the public land has been enclosed by the private respondent. Now the last cause of action arises on, my lord, the 3rd April of 2023.
Yes, come back in June. Yes.
My lord, there are three matters. The petitioners herein are students whose educational loan under a central government scheme, lordship, has been kept pending by the respondent banks. The
Last
application
cause of action.
in January 2023.
Come back in June. Yes.
My lord, I had mentioned this matter last week. Your lordship was pleased to direct it to be come up on Monday, my lord. But since this court was sitting only in the second half on Monday, my lord, and on a bridge
No,
cause.
just tell me which matter this is. I don't remember.
My lord, this matter has not been heard before. It's item 172 in your lordship's cause list even today, my lord.
What is the urgency?
Urgency, my lord, is that admitted dues of the petitioner has been withheld wrongfully since 2019 by the respondent authority, despite admission, my lord. And my lord, I'm a small business owner, my lord. My entire working capital is held
শুক্রবার
up.
দিন তুলে দাও তো। শুক্রবার তুলে দাও। Notice to the other side, please.
Very great.
My lord, I am mentioning on grave urgency, my lord, the application for grant of passport has been kept on hold by the passport office.
Since
My lord, since last 25th of April, my lord, and the petitioner reporting date in Kuwait is expiring on 25th of May, my lord. So, my lord, madam,
you are appearing in person. What are you doing?
my lord, I am appearing for the petitioner.
For the petitioner.
My lord,
What is the last cause of action?
my lord, 25th of April.
What happened, please? I don't
My
want to ask
lord,
you so many questions.
application for grant of passport has been refused.
Very well. On 16th,
Grateful.
notice to the other side, please.
My lord, the petitioner stood fast in the interview for legal aid chief counsel. My lord, next interview date was, my lord,
First, where?
my lord, he stood fast. Result was not published in the first interviews.
Which examination?
My lord, legal aid chief defense counsel for the post of North 24 Parganas. My lord, later on again interview was held, and my lord, result is to be published soon, making his first result redundant. They have not disclosed that the first one is.
What are you saying? I can't understand.
My lord, he was.
Let him come second. You wait till June. Yes, yes.
My lord, may I be permitted to mention a matter? My lord, this is my application seeking its withdrawal, my lord. I'm
On what
seeking
ground?
My lord, as per the instructions of my client, I need to withdraw.
Which year?
2022, my lord.
Yes, sir. You have to wait for the matter to come up on any of the
Well,
lists.
Lord's permission, I'm mentioning one matter. The matter relates to suspension of Aadhaar card by the Aadhaar card authorities. The last cause of action was on 16/12/2022.
Come
the
back in June.
agencies-
Yes.
The agency is my
No, come back in June. Yes.
One read petition.
I can't understand. Yes. Call on the list, please.
My lord, may I be permitted to mention one read petition, my lord, for intrusion, my lord. My lord, read petition has been filed in the month of January this year. My lord, agencies, my lord, I have been granted lease by the PWD government of West Bengal, particular plot of land. Immediately getting particular plot of land under license, I have been paying license fee to the government and complaint before the competent authority that my subject plot of land has been encroached and unauthorized construction has been made by the private respondent.
Yes, come back in June. Yes.
Bank official not only release the amount of the disease, lordship, bank official not only release disburse the amount to unauthorized person of the lies in the account of the disease husband of the petitioner.
Last cause of action.
Lordship, lordship in pursuance of the direction of the lordship.
Come back in
Bank of-
June. Call on the list, please.
Original.
Yes, original.
Original side mentioning
Yes, call on the list, please.
for judgment item number 1.
You are we care or we care less? Which one?
We can.
The foregoing reasons persuade this court to hold that the impugned notice dated 29/3/2022 and the impugned order dated 26/3/2022 suffer from a lack of statutory mandate and should accordingly be quashed and cancelled for that reason. The impugned notice and orders are accordingly quashed and cancelled, and WPA so-and-so is allowed and disposed of on that basis.
Grateful.
Yes, call on the next matter, please.
Item number 2.
The death of the petitioner's son is undoubtedly sad, and this court feels for the petitioner's pain and anguish. However, the insurance policy and the precedents on the subject do not permit interpreting any disease caused by a mosquito bite as an accident. It is neither fortuitous nor unexpected and is entirely country/city specific. The impugned refusal on the part of the insurance company to admit liability in that particular policy hence cannot be seen as arbitrary or unreasonable. This court therefore sees no reason to quash the letter dated 29/2/2022. WPA so-and-so is accordingly dismissed without any order as to costs.
I'm grateful.
Item number 4.
You are for the petitioner? Yes. Who is for the, for the other parties? Mahanadi Coalfields
I am for the respondent number 2.
and Coal India? The above reasons persuade this court to grant interim protection to the petitioner. The respondent numbers 1 and 2 are accordingly restrained from taking any coercive steps in respect of the mail dated 15/2/2023 and the letter dated 13/9/2022 until the contentions of the parties are considered further on affidavits. Affidavit in opposition by 9 June 2023, reply within 23rd June 2023, lists this matter on 27 June 2023.
Do we mention item number 5?
This is that magma matter. We received an affidavit from them yesterday, last night actually. There seems to be some
This is that suggested order?
yes, there seems to be some difficulty, and I think maybe may I just request if you could come back next Wednesday.
Affidavit stating what, Mr. Bhattacharya?
Application which you filed- I'm sorry.
No, the application that was filed at the behest of Mr. Banerjee's client, they came up with a suggested order, my lord. It is our categoric stand, my lord, that we were never a privy, my lord, to the suggested order. And if they want to pay up the entire amount, they can pay it up as penalty. They propose that they intend to pay up.
But we didn't want the finding against us, because that's the observation again. That's what we were contesting throughout. But we said just to settle it once and for all, we wanted to pay off the penalty and really to buy peace. So that
So you don't want to accept the amount?
No, we want to accept the amount, but they have to pay it as a penalty amount, my lord. That is exactly our stand.
So penalty means admission of guilt.
Yeah, that's
Yes.
Can we come back next Wednesday?
The learned DSG appearing for the respondent number 1 files the affidavit in opposition to the application for filed on behalf application of the petitioners in court today. Stop. Next, list this matter. Yes, Mr. Banerjee, when do you want to come?
Wednesday, my lord, if it's convenient, my lord, for
List this matter
Wednesday would be, my lord, 15th,
on
17th.
17th May 2023 as paid for.
19th were closing time. 17th.
Grateful.
As to be mentioned, or what is it?
As
This
to be
will now require a protracted hearing.
Yes, my lord, if either, my lord, we can, my lord, solve this issue, my lord, or, my lord, it will be a hearing, my lord, which will obviously happen.
To be mentioned at Haq,
Because I don't think, my lord, we can travel, my lord, just before, my lord.
Yes.
My lord.
Grateful.
Item number 8.
Your Lordship, I beg to appear for the petitioner. Your Lordship, three matters are analogous in nature. The relief which were prayed for, Your Lordship, in these three matters were for the preservation of the CCTV footages so that it can be audited by a independent agency, Your Lordship. But in the
CCTV footage of what?
Of English Parliament municipal election. But unfortunately, in the meantime, Your Lordship, the Honorable Supreme Court had stayed an order passed by the division bench of this Honorable Court that without filing an election petition, these points cannot be agitated, Your Lordship. That order is there.
Show me, please.
And the next date of this, it is stayed partially. It is in the month of July, Your Lordship. In paragraph numbers.
And you were the
three of them were the three of the petitioners.
No. So you were for the petitioner?
Yes, Your Lordship.
No, before the Supreme Court, you
Your
were
Lordship,
for...
no, I'm not. The petitioner was the West Bengal State Election Commission.
Yes.
The point which was agitated
Yes,
Your Lordship.
And what did the division bench hold?
The division bench had told for the preservation of the CCTV footages in an order. It is there, Your Lordship. It is in page number in the writ application 3646, Your Lordship. It is there in page number 56, Your Lordship. Paragraph number 18. Subparagraphs 1 to 5.
This is which elections?
Your Lordship, this was English Bazaar municipal election. The order which was passed in case of Kolkata Municipal Corporation that applied mutatis mutandis in case of all the other 108 elections of the municipalities, Your Lordship. So what was applicable in that order, the same is applicable in this order as well.
Very well. So what do you want?
Your Lordship, as there is an alternative forum of a election petition to be filed before the district judge of Malda, hence, Your Lordship, it is not possible for the petitioner to move this before this honorable court, because as per the order of this honorable Supreme Court, this point that whether these any challenge to an election can be agitated before a writ forum or not, that itself needs to be heard by the honorable Supreme Court. And this matter was that order was passed in the month of May 2022, and the next date is, Your Lordship, in the month of July.
Learned counsel appearing for the...
Hence, we want liberty for...
Petitioner places an order of the Supreme Court dated 9/5/2022 by which the order of the a judgment and order of the division bench dated 26 April 2022 was stayed, and the special leave petition was listed for hearing on 26/7/2022. 9/5/2022 বলেছে তো? Stop. Yes, so then you want this matter to be disposed of?
Your
What is
Lordship, Your Lordship, my prayer is that we want to agitate before the District Judge Malda for filing an election petition because there is a presence of alternative
Wait, wait,
remedy.
next,
with
council
liberty, Your Lordship.
submits that since the petitioner has an alternative remedy before the district judge Malda in terms of filing of an election petition, comma, the petitioner does not want to continue with the writ petition any further. Stop. Stop. WPA 3646 of 2022 is accordingly disposed of in terms of the above.
Your Lordship, one more submission, Your Lordship.
No, interim orders? What
No,
happens?
interim orders
Very
will
well.
pass.
Council submits that there are no interim orders in these proceedings.
Your Lordship, liberty we given for agitating before that forum, Your Lordship, in that prayer we were actually wanting to make. Liberty for
Why do you need liberty? If you say that you have an alternative remedy, what liberty do you want?
much obliged, Your Lordship. The same order is applicable for 9 and 10 as well.
Yes, which one? Which other matter?
9 and 10. Sorry,
9.
yes, Your Lordship, 9 and 10.
Let it be called on, please.
Item number 9,
Aki order.
item number 10,
Same order.
Much obliged, Your Lordship.
item number 11,
Item number 11, my lord, I am for the petitioner. My lord, this matter was, my lord, initially
I
filed.
can't hear you, please.
My lord, this matter, my lord, was initially filed as a Group 1 motion. Now, my lord, during the course of hearing, my lord, this is affidavits have been exchanged, my lord. This is at the final hearing stage.
Yes, so when was this released?
Lord, it was released by Justice Shubhra Ghosh, my lord,
Very well.
13th of February. 13th of February.
The matter was released by a coordinate bench. This matter was released by a coordinate bench on 13/2/2023. Stop. The ground for release was lack of determination. Stop. Next. This is not an assigned matter as sought to be contended, since this court appears to be the regular bench for hearing of the matter. Stop. When do you want to come back?
1 week after vacation, my lord.
List this matter on 12 June 2023 as prayed for.
item number 12,
Lord, I am appearing for the petitioner, my lord.
Yes, Mr. Dotto, you have not filed any note.
No, my lord, I have mistaken, my lord, I have mistaken.
What mistaken?
My lord, I was on.
Your learned friend, the other side, filed a note. What about you, Mr. Jahan?
My lord, this has not been filed, my lord, I have mistaken, my lord. My lord, kindly excuse me, my lord.
And the order says that parties were to hand up. Why have you not filed? Yes, learned counsel appearing for the petitioners hands up his short note. Stop. List this matter on 16 May 2023. And is it a short or a long note?
No, short note, my lord. Short note, point wise. Only bullet point, my lord.
Medium. And you have filed 2 notes.
No,
How
my
many?
lord, in 5 matters, 5 notes, separate notes.
Why? Same note.
Same note, but my lord, the pagination is different. Because, my lord, the
Just tell me what the difference is. I don't have the time to look at all 5 notes. Just tell me what the difference is. What is the difference?
difference means, my lord, in different, my lord, the writ petition, page number of the, my lord, the work order, page number of the acceptance letter, these are the different, nothing else. Fact situation is, my lord, completely same. My lord, 1 second, kindly excuse me, my lord, all are same, my lord, because he has prepared it, my lord.
No, and I
They have
I
submitted-
told my court officers that they had misplaced the notes. That's why I made them call. I thought they had misplaced the notes.
my lord, I'm extremely sorry for the inconvenience caused. by-
Yes. Next.
item number 17,
Thank you. Last order to the. No one appears for any of the parties. Stop. Adjournment had been taken on the last occasion by the learned Advocate General appearing for the state. Stop. List this matter on 6 June 2023.
Item number 18.
This is my application, Millard, challenging Millard a letter of a process, tender process, awarding Millard a comprehensive annual maintenance contract in relation to Millard Siram, ESI Sirampur, Millard. That I had argued there's a Millard, the petitioner is L2. Millard, the private respondent is L1, difference is 11 lakhs. So Millard, my argument was, Millard, there's a material breach of the terms and conditions of the tender because the mandatory documents which are enshrined in clause 19 of the tender document, like Millard, there's a form which says partnership deed has to be attached. Millard, a certificate form has to be signed by CA certificate, financial Millard of 3 years, Millard. Those are not there, Millard. And particularly is a proprietorship, Millard, which Millard offering, Millard. So it was a submission, Millard, that Millard partnership has taken over the proprietorship. No document is there, Millard. And Millard, in the meantime, there's a submission. It's recorded in my lord's order that Millard, they are not intent to award the letter of award, Millard. In the meantime, when the matter has been heard out, note directions of the notes would be filed. A letter of award has been issued on Millard 4th of May, Millard 2023, Millard. This is Millard in breach of the undertaking to court, Millard.
Which order records the undertaking?
Millard, there are 2 orders which records the undertaking, Millard. First is Millard 24th April, Millard. The learned counsel appearing for the tendering authority submits there is no urgency in the matter. There is no immediate threat to affect the work order. This was Millard the express, Millard. Then on the last occasion, Millard, on Monday, Lordship has recorded it, Millard. So this is Millard fraud on court, Millard. And Millard, there is an admitted Millard material breach of the contract. And Millard, I have cited the authority.
Admitted material breach on the part of who?
Or tendering authority. Millard, of
Tendering
the
authority has
private
caused breach.
authority, Millard, private authority of the Millard terms and Millard acceptance by the tendering authority. Clause says, Millard, there will be an outright rejection.
Yes, who's for the state? I can't hear you.
My lord, Mr. Devashish Banerjee, behalf of the respondent number 3 and 4, my lord, kindly short password is using the code number 28 hearing matter, my lord.
Mr. Ghosh, come back at 11:30.
I'll come back. Notes, Millard, I have.
Give your.
Very well. Yes. 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 Yes, Mr. Banerjee, is it correct that you have issued the work order on 4th May?
Under compelling circumstances, my lord, on 5th of May, my lord, we received a letter from them, the petitioner. They wanted for an extension. My lord, we do not have any jurisdiction or authority to extend it. So, my lord, to ensure there is no disruption of the emergency facilities, my lord, under compelling circumstances, my lord, we had to.
No, if you have no jurisdiction to extend,
My lord,
you can also issue the work order.
work order we can issue because we are the
But
tendering.
that is contrary to the position taken or rather given to the court.
My lord, on 24th, my lord, we said that there is no urgency because your lordship had fixed the matter on 26th. Till 26th, my lord, there was no urgency. But my lord, on 5th of May, my lord, they prayed for an extension. We listed.
Millard, I said, Millard, I am
One
working.
minute, Mr.
I'm
Ghosh, I will
sorry.
come
I'm
to
very sorry. I'm very sorry.
The letter says, my lord, it is also to be intimated that by 5th of each month, the salary of the engaged manpower for operational work, this is their letter, my lord. has to be paid and followed by necessary ESI and EPF contribution to the concerned staff. My lord, this, my lord, compelled us to, my lord, issue the work order, because, my lord, we did not, my lord, want the disruption of the emergency service even for a minute, my lord.
I'll not. I said only labor payment I have to make. You don't give my profit. Laborers are working. He has continued. Give me the labor payments. I can't go on. My lord, may I hand up?
My lord, this is an unstitched document.
I mean, I have given the letter. My lord, I have said, my lord, you have to give me some payments, my lord. I am continuing there, my lord. And 1 month I am doing, my lord. I am doing, no difficulty. I'll do it, my lord. But some assurance that this 2-3 months I need some payment. I have to make payment to the red.
No, these 2-3 months means what? You have not been receiving payment since when?
1 month. 1 month I have not received payment because the matter contract has come to an end. My learned friend submission that I am continuing, I'll continue. I asked them for payment for this 1 month work. My lord. Thereafter, my lord, subject to what lordship decides. For 1 month, he has continued because
Mr. Banerjee, I am keeping this matter in the first week of June.
My lord.
Till then, make the payment to the
My
existing
lord,
contract.
there is no dispute with regard to payment. Your lordship is in session of the matter. If there is a, my lord, genuine, my lord, issue with regard to payment, payment will be released.
And my lord, I'll continue to work.
Payment will be released, my lord.
And my lord, kindly take the next page. Kindly take the next page, my lord. Page 10.
Yes.
My lord, the super has issuing, my lord, all the letters, my lord, to, my lord, the hospital, my lord. This work order is a technical breach.
Very well. That I will hear after the holidays. Learned counsel appearing for the parties places a letter dated 4/5/2023 written by the petitioner to the ESI hospital Serampur, which contains a request, inter alia, for payment of the salary of the engaged manpower for the operational work by the 5th of each month. Counsel submits that the petitioner has been continuing with the said work, but has not been paid the salary for the engaged manpower for the last 1 month. It is also submitted that contrary to the position taken by counsel appearing for ESI hospital, earlier position taken by learned counsel appearing for the ESI hospital, the ESI hospital has issued a work order in favor of the private respondent / successful bidder on
4th of May
4/5/2023. Next. Since the petitioner is before the court and has challenged the tender process as well as the declaration of the private respondent as a successful tenderer, the ESI hospital Serampur shall pay the salary of the engaged manpower for the work done by the petitioner, work already done by the petitioner, work done / already done by the petitioner till the matter is taken up for hearing. There shall be no stay on issuance of the work order in favor of the private respondent. At least at this stage, It is, however, made clear that issuance of the work order shall not create any equity in favor of the private respondent and shall be subject to the final decision in the writ petition. List this matter on 12th June 2023.
My lord, the notes,
My lord, only one intelligence.
The submission,
Yes.
the notes is ready.
My lord, it would be the, not the ESI hospital, my lord, it would be the Hindustan Steel Construction Limited who has issued the work order. My lord, ESI has not issued the work
No,
order.
but the letter is written to ASI hospital.
Yes, because they are, my lord, the authority,
I
they are the
don't know
tendering
the
authority.
tendering authority is, my lord, Hindustan Steel Work Construction Limited.
Work order issued by ESI hospital যেটা বললাম, Hindustan Steel Work Construction, and who will pay the money?
My lord, the money will be paid by ESI.
By the ESI hospital. They are parties.
Next at line koda, council clarifies that the work order has been issued by Hindustan Steel Work
My lord, Construction Limited.
Construction / respondent number
3.
3, while ESI Serampur being respondent number,
The ESI is not a party, my lord. I'm sorry.
ESI is not a party because I have nothing to do with ESI, my lord.
while the money to the petitioner shall be paid by ESI Hospital Serampur, comma, who has not been made a party to the writ petition. Stop. Then how does it work out, Mr. Banerjee? Who will give the money to ESI?
My lord, ESI will be making the payment. My lord, our part is, my lord, to choose a contractor for doing the maintenance work.
That is all.
No, but then how will ESI be put in funds? How will the funds be put in with ESI
My lord, the
for making
funds,
the payment?
my lord, that I'll have to take instructions, but my lord, all the monetary, my lord, payments and everything, my lord, that is done by the ESI. Our part, my lord, is to choose a subcontractor who will do the maintenance work.
Very well.
For
Yes,
the
call on the next.
Only one thing.
Shall we submit the short notes?
My lord, short notes are ready. Lordship has
Yes.
already heard out
Yes.
the matter. May we file the short notes?
Yes, the points of arguments are filed in court today.
The only difficulty will be, my lord, there is no contract. ESI, my lord, till I get.
Let me decide that. Yes.
Wait.
Call on the next matter, please.
Item number 19.
Lordship. My lord, here, my lord, this is pertaining to, my lord, the adoption of the child, my lord. We have.
Yes, have you served them or
Yes,
not?
my lord, they have received.
When
as
did
well.
you serve them?
My lord, they have received it on the 8th of May, my lord.
Don't say they.
My lord,
Yes.
the respondent number 2 has received on the 8th of May 2023. Respondent number 3 has received on, my lord, 8th of May 2023, and the respondent number 4 as well has received on 8th of May 2023.
So all on 8th.
Yes, my lord. So this is the affidavit. The track report shows that, my lord. My lord, we have also received an intimation that
30
the
days extension.
15 days extension has been granted. We have prepared a supplementary affidavit. We'll file it in course of the day.
Very well. None of the respondents are represented despite being served on 8th May 2023. Stop. A learned counsel appearing for the petitioner seeks to file a supplementary affidavit. The affidavit of service is filed in court. Stop. What did you say? Supplementary affidavit want to file?
Yes, my lord. In course of the day, we have prepared it, but we couldn't affirm because of.
Very well. Learned counsel appearing with the petitioner submits that the petitioner that the petitioner seeks to file a supplementary affidavit to bring on record subsequent facts. Stop. List this matter on 15th May 2023.
Not sure. I'm grateful.
Next.
Item number 20.
May it please your lord. My lord, we are assailing, my lord, the tender process, my lord, on 3 issues basically.
Executive service, please.
My lord, executive service. No, I think, my lord, except one.
Oh, they had appeared. Yes.
Number 6. Only 7 is not appearing, my lord. I am filing this.
What is the tender for, Mr. Nag?
It was, my lord, consumption and construction and operation of Gati Shakti
I can't hear you.
cargo
Microphone. Yes.
terminal. So it the contract. My lord, it was construction and operation of Gati Shakti multi-model cargo terminal
by the railway authorities. The contract period cost.
I can't hear you, Mr. Nag. Microphone,
I am sorry,
please.
my lord. The tender was for, my lord, construction and operation of Gati Shakti multimodal cargo train.
Yes.
The cost was 21 crore, and the party who is supposed to get the tender is supposed to carry on the operation for 35 years. Now, my lord, we participated in the tender along with, my lord, the 3 respondents. And, my lord, there's 2, one is technical part and one is, my lord, financial part.
So why before the court?
My lord, my technical bid was rejected, my lord, without, my lord, here, my lord, granting any reason whatsoever. So, my lord, this is my first submission before your lordship. Page 44, lordship state, my lord, kindly come to page 44.
That is the impugned document.
This is the impugned document. Page 44. My lord, only, my lord, lordship will find only one line. Mrs. 5-Star Logistic Private Limited, Purbo Midnapur, your take no commercial bid against tender number such, which was due on such, has been found technically unsuitable due to following reason. Disqualification in packet A. My lord, packet A is the, my lord, technical bid. So, my lord, that is the only reason. My lord, what is the reason for me not, my lord, overcome the
Mr. Nag, Silpi Construction says that reasons need not be given.
No, my lord, reasons cannot be given. My lord,
Need not be given.
Need not be given. If, my lord, I say, my lord, the action is arbitrary and there is malafide, my lord, the court has to look into it. My lord, lordship knows, my lord, the 2023 judgment, my lord, clearly says, my lord, on this issue it can be said.
What 2023 judgment? MP power?
My lord, the judgment.
What is the judgment? MP power?
MP power.
Yes.
So, my lord, so it's clearly said, and, my lord, one thing, another 2 points, my lord, I just, my lord, indicate the point, and then, my lord, I will place the points of law. My lord, here,
What
I
is
say,
Mr. Nag, I don't want to interrupt you, but just show me that it is arbitrary, discriminatory, malafide, whatever, the usual. Tell me.
lordship. My lord, I say, my lord, there has to be a reason. If there is no reason for, my lord,
Mr. Nag, prima facie, I'm satisfied that the reason is sufficient. Prima facie, I'm satisfied. What is your other point?
my lord, the other point is, my lord, lordship kindly takes the last page. There is, my lord, in the tender process also, my lord, there is a direction on the respondent authorities that there are technical glitches that has to be removed.
Technical glitches for what?
For, my lord, it's a, my lord, complicated tender process. Here, my lord, I can bid even more than 100%, my lord. But here, lordship sees, they admits that there is a glitch and the glitch was not rectified. This is point number 2.
Who is they?
My lord, the railway authorities, my lord, the main respondent.
So railways floated the tender.
Railways floated the tender and there is a direction on them, and in spite of that, there was glitch.
No,
Now, my lord,
so if there's a technical glitch that was not cured.
that was not cured.
How do you know? Show me documents, please.
There is no document, my lord, to show that it's, my lord, pleading is there.
Pleading
Yes.
will not do. Next point.
Now, my lord, the last point is, my lord, the respondent number 5, my lord, why I say malafide, and, my lord, I go back and connect it with, my lord,
Who is
the
respondent number 5?
respondent number, respondent one of the successful.
The successful bidder.
Successful bidder
Yes.
in the technical bid. My lord, respondent number 5.
Mr. Banerjee, take your seat. Yes.
Respondent number 5 and 7, they are the alter ego, and, my lord, they have manipulated.
Alter ego?
Yes.
Alter ego of who?
Of respondent number 7 is the alter ego of respondent number 5.
Are you sure you've got it right, or it's the other way around?
My lord, my instruction is, my lord, the respondent number 5, he is participated in the tender with, my lord, this respondent number 7. They set up this respondent number 7.
But I thought you said 7 is the alter ego of 5.
My lord, it is 5 has basically, my lord, set up this respondent, and, my lord, they are basically, my lord, that is why I say there is an element of malafide, and that is why that has to be looked into.
Mr. Nag, I don't have to tell you. You can't make these submissions without corroboration.
My lord,
when you're saying alter ego, I don't see anything wrong with it unless one of the 5 or 7, I could not understand, has been given particular favor, excluding the others in a fashion which is malafide. You tell me, you show me that.
Well, that, well, I do not have document. Well, I say the reason, the cryptic reason given in the impugn notice makes itself clear.
Mr. Nag, I have seen worse. I have seen worse and worst, where it is just rejected. That's all. This is sufficient.
Well, kindly have a look at the judgment, once, two paragraphs.
What judgment?
Of to the AB power, two paragraphs.
Since you're coming after a holiday, I will give you that chance to show me 2 paragraphs.
But
Otherwise, no relief. I'm telling you.
The document
Just for your satisfaction, show me which paragraph.
Kindly. Just a moment, first, paragraph 6. Here also.
Paragraph
6,
6.
Paragraph 6, here also, the technical bid was rejected.
It has 222 to 222 paragraphs. You're only on paragraph 6.
Just to show, it was also rejection. Kindly, moment.
Mr. Nag, should I dismiss the writ petition or give them a chance to file their affidavits? What do you
There
want?
has to be affidavit. They have to disclose the tender documents, showing that.
Showing what?
The reasons. And reasons, and also the 5.
Mr. Nag, is it correct? From what I remember from the last day, is it correct that there is no successful bidder declared as of now?
As of now, not.
No.
As of now.
Then what is the grievance?
Well, my grievance is I am out of the our tendering process. I am now not in the tendering process, because they say in one line you are not qualified, or you are disqualified. Now, what is the reason of disqualified?
So the reason is there. What is the grievance?
No. What are there are 2 stages of contract. The first stage is when the contract is formulated. In that sphere, there is scope of judicial review, and there is apparent arbitrariness like this by the respondent authorities. Then I think lordship should exercise jurisdiction, because after the contract is in.
Mr. Nag, that is not a 5-star point.
So, 2 things, I need to, know, and I have the apprehension of arbitrariness and, malafide, and I am submitting the point before your lordship. First, the cryptic reason given, what is the reason? Because I say, whatever the technical.
Let me hear what the others have to say, then I will decide whether I will dismiss or ask for affidavits. Yes.
Yes, my lord, I beg to appear on behalf of the Railway Authority.
Tendering authority?
Railway Authority.
Tendering
Authority.
Yes.
The clause 15, that is at page 25, if your lordship kindly sees once. It is, in the process, it was specifically mentioned that the railway administration reserved
clause
15, page 28.
Page
28 of the writ petition. My lord has got it?
Yes.
Yes. Clause 15.
Yes.
This is first part. Now, my lord, the second part. If your lordship kindly come to next page.
First part, second part. What is clause 15? What is your point?
Yes, point is, my lord, we are not duty bound to disclose anything. The railway administration reserves the right to reject any or all of the tender offers without assigning any reason whatsoever, or to accept any tender with a higher offer. Number 1. Number 2. Now the why we have rejected, my lord, we are. My lord, if your lordship kindly sees the page 29 once. Page 29, my lord,
Yes.
17.1 eligible firms, that is company registered under the Companies Act. Now, my lord, right hand side, 4, notarized and registered copy of power of attorney in favor of the individual to sign on behalf of and to create liability against the company. That was not there. In the packet A, that was not disclosed. This is first part.
Which point are you placing? I can't find
my lord, page 29, my lord has
Yes,
got
page
it.
29.
Page 29, 17.1, eligible firms, what they have to file. Now, my lord, column, my lord, D, A, B, C, D, companies registered under the Companies Act.
Yes.
Now, right hand side, my lord, the 4,
Yes.
notarized or registered copy of power of attorney in favor of the individual to sign on behalf of and to create liability against the company. That was not disclosed in the technical A, that is in packet A. And lastly,
They probably didn't disclose it because they didn't understand. Like I also can't. What does this mean?
Because, my lord, the issue is whether the liability against the company who will file that, they have to disclose it. Who will create and, my lord, who will bear the liability of the company. That we have indicated. They were not dissatisfied when we have issued the tender.
Very well. Your next.
Now, next part, my lord, they ought to have annexed the, my lord, self-attested Aadhaar, photocopy of the Aadhaar. That has not been done.
Yes.
Lord, these are the three issues, my lord.
Is that a requirement?
Yes, my lord. We have indicated that. That is the, my lord. Yes.
You have only said disqualified in packet A. What does that mean?
Yes, packet, my lord, there are procedure in two parts. Packet A consists, my lord, the technical part, and the packet B, financial bit. Now, packet, unless and until you qualifies in the packet A, thereafter only.
Show me from the tender documents, please.
Yes, my lord, if your lordship kindly sees, that is at
Yes,
page.
Mr. Bachawat. Yes.
Please take page 28.
Yes.
Page 28, if your lordship will take note. Page 28, clause 1.2. Now, there are two parts. One is the technical part. The other is the not financial part. Packet A is the technical part. 1.2 in the first packet, bidders will be evaluated on the following criteria. And Lord, your lordship will find whether the bidder fulfills the minimum eligibility criteria, essential mandatory, and submission of relevant mandatory documents as stipulated in para 17 below. Lord, your lordship turns the page.
What are the mandatory
Yes, Lord,
documents?
please turn the page. Para 17 is on the next page. Heading minimum eligibility criteria. 17.1 is eligible firms, categories permitted shall be as under. Categories are given, and on the right side are the mandatory supporting documents. Now, from my learned friend's submission, it seems that Lord, the writ petitioner has not given these mandatory documents. This is his submission, Lord. I have other submissions which not.
Very well. Yes, Mr. Bajawat. Yes, make your submissions.
Yes, Lord. Lord, it seems from the submission.
You're what? One of the participating
yes, Lord.
bidders.
Lord, I have succeeded through the technical bid. Lord, I have succeeded through the technical bid. After that, the financial bids are to be opened. There are other Lord, participants there. Today, no tender has been granted. The question is whether
Your respondent number?
Lord, 6.
Yes.
Now, Lord, as far as we are concerned, Lord, it's quite clear over here that these were mandatory requirements under clause 1.2, submission of documents. Now, my learned friend says no reasons given from his disclosure at page 44. The reason is not given. It says that non-compliance comments disqualified in packet A. Packet A are the technical requirements. Your lordship has seen that these are mandatory requirements. And Lord, it's quite clear that he has not submitted documents which he was supposed to mandatorily submit. So, Lord, it is liable for rejection. Although the law is not, as your lordship has not rightly said, there is no requirement to give not reasons, but in this case, there are reasons. Lord, if your lordship wants, Lord, I'm supported by judgments also, Lord. Lord, it's too well settled the problem.
Not required to give reasons on
Yes,
that point.
While rejecting
Silpi.
tenders, Lord, 2016-14 SCC 172, that state of judgment. Not the other judgments I'm carrying also.
SCC?
You don't need it, Mr. Nag. Yes, which paragraph, Mr.
Yes,
Bachawat?
Yes,
14, 16,
I'm answering the judge now if you keep not paratable. But please take paragraphs, not 14.
হাতে মার করে ট্যাব খুলে করা যায় না কপি আনিসটা তো এখানে তো লেখা আছে কোনো মার্ক করা
Yes. No, where does the Supreme Court come to this conclusion that the state was well within
Please
its
give
rights?
me a moment, Lord. My iPad was locked, Lord. I've not clear. Please, Lord, comes to para 14, Lord. The appellant state will be well within its rights to reject the bid without assigning any reasons thereof. This is apparent from clause 24 of the NIT. And, my Lord, your lordship sees that the clause there is similar. Authority reserves the right to reject any or all of the tenders received without assigning any reasons thereof. Employer reserves the right to accept or reject any bid. Lord, there are identical conditions here, which I'll show your lordship.
Clause 15.
Yes, Lord.
Yes.
There are two clauses. There, Lord, there's another one. If your lordship, Lord, please take page 37. 90, no, dekhi.
Yes.
Page 37, clause 38. The railway reserves the right of not to invite tenders on any railway works or to invite open or limited tenders when tenders are called for, to accept a tender in whole or in part, or reject any tender or all tenders without assigning any reasons. My lord, this is there, and also, my lord, at page 19 there are similar clauses. My lord,
That is all. Mr. Bajawat,
my lord.
anything else?
But,
Yes,
that's
Mr. Banerjee, your for response number
5. But I am stated to be the alter ego of
7.
7 or either way. That
one sentence, if I may add. But there are no allegations of malafides or arbitrariness apart from one bare line saying it. But there is nothing to indicate this in the pleading.
Very well. Yes.
on a slightly different point, my lord, your lordship being called upon to decide something which is not under challenge here. Your lordship will have a look at the prayers in the writ petition. There are two parts to his challenge. One is his rejection. If his rejection is bad, then he comes into the tender. There is no prayer challenging the rejection at all.
Says quashing the tender.
Tender, that's right. So he argues that tender is being awarded. This is not a public interest litigation. He's come up to espouse his grievance, challenging the rejection. There are no prayers in the writ petition. This is not even an issue in the writ. On this, I'll show one decision, my lord, where the basic order is not under challenge, consequential reliefs can't be granted. His basic order that allows him a foot into the tendering process is rejection. There is no challenge to rejection. What is left is just.
Yes.
So, you know, all of us are arguing on a point that is actually not under challenge here, because his rejection has come by way of a document at page 44, single packet A, whatever. He's not challenged there.
Very well. Yes.
That kindly allow me to rely on one decision, 2010 volume 1 Supreme Court cases 752 paragraph 22. 756, I'm sorry, paragraph 22. Lordship will forgive me, I just have one copy of this.
No, you place it and then you hand it up.
Yes, my lord. It is a second legal proposition. The challenge to consequential order without challenging the basic order or statutory provision on the basis of which the order has been passed cannot be entertained. Therefore, it is a legal obligation on the part of the party to challenge the basic order, and only if the same is found to be wrong, consequential orders may be examined. So if his cancellation of his tender process is not under challenge, he is a nobody with regard to him challenging the tender process. That will be consequential to him having shown a cause to say that he's been thrown out of the race arbitrarily. This argument of it being arbitrary, court can look into reason.
That is all. Yes.
I was also carrying Soma, I'll not cite that, except that to provide reasoning is a facet of a principle of natural justice. In matters of tender, principles of natural justice are kept at bay. On this, my lord, AIR 2009 Supreme Court 1204. Paragraph 34. No?
Oh.
This is, of course, a lesser point than what Mr. Bachawat has argued, because that appears to be the law now. So the line about 4 from top of that paragraph. 34, sorry. 34. Line about 4 from top of that paragraph.
Yes.
When the power of judicial review is invoked in the matters relating to tenders or award of contracts, certain special features have to be considered. A contract is a commercial transaction, and evaluating tenders and awarding contracts are essentially commercial functions. In such cases, principles of equity and natural justice stay at a distance. It further goes on to hold that if there's a procedural lacuna also, court will not. But I don't want to go that far. I don't need to, my lord. 2 points only, apart from what has been argued, apart from this being absolutely premature in the absence of any challenge to his rejection. So he doesn't really have a foot in the door. This writ is not maintainable.
And what is the other one you cited?
This is the one, the 2010 volume, when I just hand it over, my lord.
Yes.
2010 volume 1 Supreme Court cases 756.
No, that is fine. Paragraph
22. Those are my respectful submissions.
Yes. What about the 7? What about 7?
7 is, I don't know, my lord, with regard to his allegation that I am an alter ego of 7 or 7 is my alter ego. Not a scrap of paper to justify something like that. It's a mere bald assertion without any document. And I'll be able to show if your lordship feels, that it's completely unconnected. The petitioner probably got
Yes,
confused.
that is all.
Yes.
My lord, may I gather courage, my lord, to give one suggestion, my lord, that may cut short the matter. No, no, financial bit has not approved. My lord, the defects I was not aware. My lord, these are basically minor defects, my lord. If I can correct and put it, my lord, I can participate in the tender process. My lord, I have not signed the Aadhaar card. That cannot be, my lord, cannot be a big ground, my lord. It can be, my lord, I don't have the financial worth means, my lord, that can be. My lord, there is, my lord, some notarized copy has not been given. Even I cannot understand what I have to give. My lord, if I can comply that within 1 day, my lord, it is, my lord, is, my lord, very small minor mistakes, my lord.
How do you respond to that?
Yes, my lord. On 24th April, my lord, packet B has been opened already. We have opened the packet B. Now, my lord, the packet A cannot come.
One line, if your lordship permit me, brother.
Clause
1.2.
My instruction is.
But clause 1.2, it's a mandatory essential requirement. Not. That's the wording of clause
But
1.2.
Aadhaar card, I have not signed that.
Yes, heard learned counsel appearing for the petitioner,
Packet B has been opened.
comma, the respondent numbers, the railways / the tendering authority, comma, the respondent numbers 5 and 6, who were two of the other participants in the tender floated by the railways for construction of a cargo terminal. Stop. List this matter tomorrow under the heading for orders, for judgment.
Lordship. I'm grateful, madam.
Item number 21.
Should I pay for the petitioner?
Yeah, for the respondent number 2, your lordship.
Well, we have prepared a convenience volume because the petition is thick, runs into 4 volumes.
So what are you saying? You have prepared a voluminous index. What are you saying?
No. A so-called convenience compilation. Well, often it becomes inconvenient, but this
Yes.
possibly cannot be branded as an inconvenient one.
Yes.
Now, my lord, the Metro Railways, my lord, they had floated a tender, my lord, for my lord, installation and maintenance of, my lord, air conditioning plant, my lord, in the Biman Bandor metro station that is to come up. Now, my lord, respondent number 3, that is Universal. It is a big name here. In short, my lord, I call it.
Why are you saying Biman Bandar? It says that, or not the airport?
No, it says Biman Bandor metro station.
Yes.
Now, respondent number 3 is a, my lord, wholly owned subsidiary of the.
Respondent number 3.
Yes, its name is Universal. It's a big name, but in short, I call it Universal. Universal MEP Projects and Engineering Services Limited.
Yes.
Now, my lord, the petitioner, Voltas, my lord, in October 2021, my lord, had decided to transfer its business to Universal, that is the respondent number 3. Now, thereafter, my lord, or before that, an NIT was filed by the Metro Railway authorities on 20th of September 2021, my lord.
Yes.
This the NIT is at page 49, my lord.
Yes.
Now, my lord, on 18th of October 2021, my lord, Voltas, the petitioner, my lord, informs the tendering authority that they have already entered into an agreement for transfer of business in favor of Universal, and puts them on notice that if Voltas is successful in the bid, then Universal will carry on with the work or execute the work. Voltas, ultimately became successful in the bid.
And didn't you mention a year when this business was transferred to the respondent?
There was an agreement, on 18th of October 2021. No, I'm so sorry. It's on 12th of February 2021. I'm so sorry.
Yes. Agreement to
for-
transfer the business to the respondent number 3.
3. But this was, my lord, made known to the respondent which had invited the tender.
Yes.
My lord, an LOA was issued in favor of Voltas being the successful bidder in the tender. Now, my lord, after it became successful, my lord, the LOA is on 1st of March 2022. On 7th of March
1st of March 2023.
22.
Yes.
On 7th of March, Voltas informs, my lord, the tendering authority and seeks their confirmation in regard to novation of this agreement, which would be executed between the parties. This your lordship would find, my lord, at page 288. But for the time being, kindly, your lordship need not be troubled with this.
Mr. Dotto, I hope you will finally come to 2023 for some cause of action.
I'll tell you, lordship, today, my lord, I am, my lord, on 2 things. Number 1 is termination of the contract, and the second is, my lord, invocation of the bank guarantee. Now, why I need to take your lordship through this history is because, my lord, this is where, my lord, there was an understanding between the petitioner and the respondent that the contract will ultimately be novated, and there was an in-principle approval of the novation by the respondent.
So you did not do the work.
No, I was executing the work.
Then why termination?
Yes. Milord, they call it termination, but I'll come to that. Milord, only, Milord, permit me to place, Milord, 1 or 2 letters. Please take the in-principle approval. Please take the date. I'll not trouble your lordship, on 31st of March 2022.
Yes.
Page 11 of the compilation, kindly note down the page number.
In principle approval of what?
Of the novation agreement, which would be executed in favor of Universal. Then, Milord, the
novation of what?
Of the contract that is awarded in favor of Voltas. Or in other words, Milord, Universal will be permitted to execute the work or the contract which has been granted in favor of.
The LOA is, if the letter of acceptance is in 2022 and the agreement to transfer is of 2021, then why would you need a novation?
Because, Milord, when I participated in the tender, Milord, the process of the entire transfer was not over. Therefore, I had put on notice that if I am successful, this will be done by Universal. And Milord, this has been accepted by them. They have granted the in-principle approval. They have vetted the, Milord, the proposed novation agreement, which your lordship will find, Milord, at page 307. Please note down the date, Milord. I'll not trouble with all these documents. On 5th of April 2022, Milord, the Metro Railways vet the proposed novation agreement.
Yes.
Then, Milord, ultimately, Milord, there were various correspondences, Milord. I don't take your lordship through all those for the present moment. And finally, Milord, they come on 19th of April 2023 and regret the novation or allowing the novation that your lordship would find at page 809.
This is what is under challenge.
Milord, no, this is the process, Milord, which goes on. Where it's a lengthy process, where I have taken your lordship at the first instance and the last instance. And in between, the Metro Railway also writes to the RITES, the inspecting agency, that Universal is going to execute the agreement. So whatever inspection you have to do is at the instance of Universal. But everything was going fine. Ultimately, Milord, they come and finally say that no, we cannot allow this novation agreement. This is, Milord, one part of my affectation of my right. That, Milord, my principal argument is that this is hit by promissory estoppel, because you could have said on the first day that no novation, I wouldn't have proceeded with the contract. This is,
and is there a contract or not?
Milord,
So how firmly would promissory estoppel stand against the contract?
Milord, promissory estoppel, as your lordship knows, Milord, if there is a promise that one of the parties would do something.
MP Sugar.
MP Sugar is there, Milord, I have Lotus with me. And Milord, if the other party, based on promise, Milord, acts to his detriment or its detriment.
And there's a recent one, 2020 by Justice Chandrachud.
Yes. 2019, I'm told, Milord. So, Milord, the first is, Milord, you cannot come out and say that we regret the execution of the novation agreement. So this is my first submission. My second submission is Milord, when we go for execution of the agreement, Milord, there was an meeting held on 21st.
Execution of the novation agreement.
No, the main agreement. The main agreement also has to be executed.
That is a 12/2/2021 agreement.
Yes. 12 to 21 is between Voltas and Universal.
Yes.
Number the main contract, there has to be an agreement
So
executed.
contract pursuant to the LOA.
Yes.
That is the contract
Yes.
you're talking about. Yes.
Now, Milord, there was a meeting held on Milord 21st of December 2022, where Milord the railways accept that the agreement execution will be only after the novation agreement is executed. This your lordship will find at Milord page 482.
Railways accept what?
That the agreement, the principal agreement will be executed after the novation agreement is executed. That your lordship will find Milord from page 482 of the writ petition.
Yes.
But the third parties, Milord, in between Milord, we were doing some work for which Milord we had applied for. I mean, Voltas applied for extension of time. Milord, the Metro Railways, Milord, grant me extension of time till 31st of October 2023 without imposing LD. But this is the third aspect of the matter, which is very important.
Which says that delay is not attributable to any party.
Extension till?
31st of October 2023.
Yes.
Now, Milord, this extension granting clause, Milord, has three parts.
And granting extension to do what?
To do the entire work. Because if the Milord contract period is over, then Milord, there is no use of any novation or Milord any other.
So the contract period was getting over before 31st October?
Yes, yes. 28th February, it was getting over. Milord, we had applied for it on 24th of February, and then it was extended till 31st of October 2023. Now, Milord, the extension clause has three parts. One part is when extension is granted for the fault of the contractor. The other is when extension is granted for fault of the railways. And the third is, which has been invoked in my case, where there is no fault on the part of either of the parties. Therefore, when Milord, this clause is Milord invoked by the Metro Railways for extending the contract, Milord, it presupposes an acceptance that neither the contractor nor the railways were responsible for delaying execution of the work. But after this, now Milord, the whimsical action starts at page 807, where Milord, they issue a show cause notice to me on 17th of April 2023. The compilation at page.
So show cause follows the invocation of the
no
extension.
But after show cause made, there are various letters made on novation. I don't trouble your lordship. Then Milord, termination. This is a 48 hours notice, and then Milord, on 24th of April 2023, Milord, there is a so-called termination letter on the ground that there is no progress.
24th April 2023.
That is page 810. A compilation.
Page 29.
Milord, please take Milord page 29 of my lord's compilation.
That is the 48 hours.
Yes, I'm sorry, it's a 48 hours notice. Yes.
Serial number 13 and 14 of the compilation.
Milord, serial number 13 of the compilation. Kindly have a look, Milord. Yes.
Each of the pages has about 4 sets of numbers.
What is the number?
Page 29. Which one are you?
Page number 27 of the compilation.
The page number 27 of the compilation is dated 17th of April 2023.
This is a termination?
No, this is the show cause notice.
48 hours notice.
Or 48 hours notice.
Sorry, 17. 17. 7.
Yes.
8.
Yes.
8. 7.
Yes. But please see the subject at page page 27. Subject is 7 days notice for the work, etc. Then paragraph 1 below that, in spite of repeated instructions to you by the subordinate officers as well as so and so, dated, etc., you have failed to start the work, show adequate progress and/or submit detailed program for completing the work. Your attention is invited to this office letter, number, etc., video so and so. As you have failed to abide by the instruction issued to commence the work to show adequate progress, you are hereby given 7 days notice in accordance with clause 62 of the standard terms and conditions. Now, my lord, this is followed by.
So did you start the work in 7 days or not?
No, but no, the work is continuing. That is why, my lord, the extension of time is given. Now please take, my lord,
No,
the
but
next.
this does not talk about any extension.
No, extension, my lord, was granted prior to that. Extension was granted on 28th of February 2023. Page number 25 of the compilation. So you grant me extension till 31st of October 2023, and before 2 months expire, my lord, they issue this letter dated 17th of April 2023, giving me 7 days notice in terms of clause 62. My lord, I'll come to the clause later on. Now please take, my lord, the document 24th of April.
Mr. Dotto, you need a convenience to the convenience volume.
Yes. My lord, page
Yes.
29. My lord, I'm so sorry, my lord, I'm troubling your lordship, my lord, with these voluminous papers. Now please take, my lord, page 29 of the compilation.
Yes.
Now this is a follow-up of that 7 days notice. Please take the bottom of that page. 7 days notice under clause 62 of so-and-so was given to you under office letter number so-and-so, but you have taken no action to commence the work, show adequate progress of the work. You are hereby given 48 hours notice under in terms of clause 62 of the so-and-so to make good the progress of the work, failing which the expiry of this period, your above contract will be rescinded and the contract will be carried out independently without your participation, and your security deposit will be 24th April 2023. No, this is 24th of April 2023, which says that your contract will be rescinded.
So what is under challenge?
Yes. Now the offending document, my lord, your lordship will kindly take, my lord.
So you're not offended by any of these documents?
No. This is the entire process of the illegality that is continuing.
Yes.
But what is my present grievance before my lord, or the on the interim order aspect is, my lord, after this, my lord, they have written to the bank invoking my bank guarantee. In between. Yes, in between, right. On 19th of April, that your lordship will find at page 36 of the compilation. Right.
Have you served the railways or the answering respondents?
My lord, the affidavit of service is with my lord.
You're appearing for the railways?
No, I'm appearing for Axis Bank, respondent number 2.
Axis Bank. Show me the affidavit of service, please.
No, it's here, my lord. Kindly permit me to affirm it and give it to your lordship, my lord. Railway by hand.
Served on 9th of May by hand.
9th of May, by
hand.
I can show it to you.
That's all right. If you say it.
We will affirm it and we will file it in course of the day.
Yes.
Now, please take, my lord, page 826, which is page 36 of the convenience compilation.
Yes.
Please treat this letter as an advisory for encashment of the. Yes, this is on 19th April. That is in between 17th and 24th. Please treat this letter as an advisory for encashment of the bank guarantee number, etc., for 2 crore, etc., and arrange to remit the said amount of rupees, etc., by account pay check in favor of so-and-so. The contractor has failed to execute the work as per the contract condition. The above contract has been terminated. In consequence of termination of the contract, the Metro Authority has approved the forfeiture of the bank guarantee in terms of the GCC. First is, my lord, therefore, my lord, these 2 dates are very important. First is the show cause notice on 17th of April 2023, invocation of the bank guarantee on 19th of April 2023, and, my lord, the proposed termination on 24th of April 2023. Now, please note these 3 dates, my lord, before I address your lordship, my lord, on the bank guarantee aspect, why I am entitled to an injunction at this stage. The bank guarantee page tada.
So you want to formulate a new point for a restraint on
Yes,
invocation of bank guarantee?
I'll tell you, lordship, why. First is, my lord, a bank guarantee can be conditional or unconditional. My lord, I'll take your lordship, my lord, through the terms of this bank guarantee, which makes this bank guarantee a conditional one, number one, and number two, as per the conditional bank guarantee, the condition has not yet reached. Therefore, my lord, please have a look to the bank guarantee. which is at page 17 of my lord's compilation.
Yes.
Please give me a moment, but I've marked it in my volumes. Yes, yes. So please take, my lord, the bank guarantee. Please have a look to the clauses. But in the first paragraph, instead of taking your lordship in its entirety, please take, my lord, the last 3 lines of the first paragraph. Hereinafter called the said agreement of security deposit for the due fulfillment of the said contractor of the terms and conditions contained in the agreement on production of the bank guarantee of rupees, etc. Now, my lord, the conditions. We so and so bank, a banking company, my lord, then comes the address. My lord, after the address, hereinafter referred to as the bank, which expression shall, unless repugnant to the context or meaning thereof, include successors, assigns of the business, at the request of Messrs. Voltas Limited, contractor, do hereby undertake to pay to the government an amount not exceeding so and so against the number 1, any loss or damage caused to or suffered or would be caused or suffered by the government by reason of any breach of the said contractor of any of the terms and conditions contained in the said agreement. So the first condition is any loss or damage suffered by reason of any breach on my part. This is number 1. Kindly take the next condition. Paragraph number 2. We so and so bank do hereby undertake to pay the amount due and payable under this guarantee without any demur, merely on a demand from the government stating that the amount claimed is due. Then, by way of loss or damage caused to or would be caused or suffered by the government by reason of breach by the said contractor or any of the terms and conditions contained in the agreement, or any reason, or it should be by any reason of the contractor's failure to perform the agreement, any such demand made on the bank shall be conclusive as regards, etc. Therefore, my lord, both the clauses, that is the first paragraph, last 3 lines, 4 lines, and the second paragraph, my lord, both indicate that there has to be a loss or a damage suffered by, there are 3 situations. Number 1, 2 situations. Number 1 is breach by the contractor, and number 2 is failure to perform the contract. Yes. Now, please come back to the
loss suffered by the government.
Yes.
Government is what? The railways. Says loss suffered by the government.
Because the contract is entered into the name of the president.
Yes, yes. Finally, because my lord, the contract is executed between the President of India and the successful bid. Yes. But these are all Article 299 contracts. Therefore, my lord, it's signed in the name of the President.
Yes.
Therefore, my lord, loss and damage under 2 situations. Now, please come back to the invocation letter once more.
36 of the compilation.
Which is at page 36 of the compilation. Where the ground is, there is a failure to execute and the contract is terminated. Termination of a contract.
Just 1 minute, Mr. Dotto. One is the loss and damage suffered by the government. That's 2 at
Yes.
page 19.
Yes.
And the other one is
Clause number 2.
clause number 3.
No, it's 2, my lord.
Yes, 2. The other one is what?
The other one is, my lord, in clause 2, my lord, your lordship finds it's broken in 2 parts.
Yes.
Loss and damage either by breach by the contractor, or the second part is failure to perform the agreement.
Yes.
So therefore, there has to be a loss.
So you come under the second, no?
No. A failure, loss and damage caused by failure.
Yes.
2 parts. Loss and damage caused by breach of the contract. The other is loss and damage caused by failure to execute the work. Now, there has to be a loss or damage.
And suffered by the
And the expressions are very clear, suffered by the government. I could have understood the simple language of the bank guarantee has been quoted in the invocation letter. I would have been out of court. The invocation letter says that I have failed to execute the work and the contract has been terminated.
So your alleged non-performance has not resulted in loss or damage.
Loss and damages, number one, and number two is, my lord, termination. Simpliciter is not a ground for invocation of the
Extended the time without imposing LD because there is
With the other parts may have already submitted, my lord. If, my lord, the time is extended without LD, imposing LD, what is the effect? The effect is that the employer felt that there was no willful default or failure on my part.
So, Mr. Dotto, you're saying at page 36 of the volume,
Yes.
the reason given is that you have failed to execute the work,
Yes.
but that is not reason sufficient.
That is not as per the tender, bank guarantee conditions.
and the reason
What should have said? What should it have said?
They could have said that we have suffered loss and damage owing to failure on my part, or loss and damage owing to breach on my part.
Yes.
One judgment, my lord, this is, my lord, still a valid law. Please have a look to this judgment, my lord.
That invocation must be in terms of the bank guarantee.
Yes. And, my lord, the inherent fraud into it, my lord, which I also should, my lord, indicate to your lordship, my lord, that, my lord, as on that date, my lord, as I've said, my lord, there are 3 dates important. 17th April, 24th April, and in between is 19th April, invocation. As on that date, my lord, there was no termination on 19th of April.
But today there is no termination.
In fact, today also there is no termination because they proposed to terminate by the letter of 24th of April.
But that becomes less relevant in terms of clause 2
Yeah.
of the bank guarantee.
Right. Now, my lord, please have a look to, my lord, this judgment reported in 1999, volume 8, Supreme Court cases, page 436. Where, my lord, the Supreme Court says that the terms of the bank guarantee is very important. You have to read it and understand. But this is reported in 1999, 8 SCC 436.
Who must understand? Who must understand?
Yes, yes.
No, I'm asking you, what does the Supreme Court say?
But Supreme Court says that if it is you must go into the terms of the contract, and contract means the bank guarantee contract, and both parties are bound by those terms. But this is very important. Please take note paragraph 9 first.
Yes.
What is important, therefore, is that the bank guarantee should be in unequivocal terms, unconditional, and recite that the amount would be paid without demur or objection and irrespective of any dispute that might have cropped up or might have been pending between the beneficiary and the bank guarantee or the person on whose behalf the guarantee was furnished. The terms of the bank guarantee are therefore extremely material, since the bank guarantee represents an independent contract between the bank and the beneficiary. Both the parties would be bound by the terms thereof. The invocation thereof will have to be in accordance with the terms of the bank guarantee. This is where, my lord, I lay emphasis. Or else the invocation itself would be bad. So, my lord, we need to, my lord, understand, my lord, the bank guarantee conditions. Now, where the Supreme Court also says that it is binding between both the parties. My lord, kindly have a look to, my lord, paragraph 13 and, I'm sorry, 14. This condition clearly refers to the original contract between so and so, expressed in the contract are not fulfilled, giving the defendants, etc., advance mobilization loans, etc. Miller, kindly take, Miller, the next, skip over the next sentence, and then the sentence starting with the bank guarantee. The bank guarantee thus could be invoked only in the circumstances referred to in clause 9, whereunder the amount would become payable only if the obligations are not fulfilled or there is a misappropriation. Well, that's in the under the bank guarantee clause over there. That being so, the bank guarantee could not be said to be unconditional or unequivocal in terms, so that the defendants could be said to have an unfettered right to invoke that guarantee and demand immediate payment thereof from the bank. This aspect of the matter was wholly ignored by the High Court, and it unnecessarily interfered with the order of injunction granted by the single judge, by which the defendant was restrained from invoking the bank guarantee. Then, my lord, finally, my lord, the Supreme Court said that
Very good. Anything else, Mr. Dattu?
Milord, this is only one. Number two is, Milord, I had, Milord, submitted that, Milord, there is an inherent fraud into it.
Inherent?
Fraud into it, because the day, Milord, it was invoked, Milord, there was no termination, and Milord, our understanding of the letters are that even today there is no
Where
termination.
does page 25 say that is extended till 31st October?
Yes, Milord. 522. But the first paragraph, kindly have a look, Milord. Reference above the present, the period of completion of the contract has been extended up to 31st October beyond 26 to 23 without imposition of LD in accordance with clause 17A II of the Indian Standard. 17A II is, Milord, where, Milord, extension is for no fault of either of the parties, which is, Milord, page 6 of my Lord's compilation, Milord. Please have a look, Milord, page 6. Where there are three parts. First part is I, Roman I is extension due to modification. Then II is extension for delay not due to railways or contractor, where they have extended it, Milord, under 17A II. And 3 is extension due to for delay due to railways.
Very well. So yours is II is important.
Yes, therefore, Milord, on the day the extension was granted, Milord, the railways were of the opinion that there was no fault or delay on either side.
What is the interim relief you want?
Milord, for the present period, I am seeking, Milord, in the prayer orders in terms of prayer.
Prayer I?
No, Milord.
H and I?
H. HI. Yes. Yes. H and I.
K also.
K থেকে কি করবে?
48 hour notice and 7-day notice, and they're saying it's terminated. They can't
Yeah,
take
K
any
also,
action.
right. K also. 48 and 7 days. 48 hours and 7 days.
But the 48 hour and 7-day, they just don't even mention what the breach is, what I'm supposed to do. They've copy pasted the format. Judgment is this some non-application of mine.
No, so you don't want to start work between within 7 days and all that.
But I'm working.
No, then why do you want K? If you're working, then why is K important?
But K, because, Milord, the last notice that I've shown to your Lordship on 24th of April, which says that they are proposing to terminate. But please have a look to, Milord, this once more, Milord. 24th April.
Yes, the last paragraph.
Yes.
Last one.
Rescinding the contract.
Yes, yes.
But they must tell me what my breach is. Here they don't. They just copy paste.
Very well. Show me the affidavit of service, please.
Yes.
Affidavit. Here they just copy paste the format. You fail to start, fail to
But
make.
there's a format over there, Milord, in the contract itself. It just they copy paste it. They do nothing. Milord, we'll affirm it and give it to your Lordship, Milord. Today, where there's a
Which page shows that they have received?
With the one jeta khole diyechi. Page 4. But at the bottom, your Lordship finds, Milord,
By email on the 8th of May 2023, and the next page is 9th of May 2020.
Yes, you're
for the present, Milord, I'm not troubling your Lordship. Yes.
Do you want to say anything?
Yes, my lord, we've been received a letter from the Metro Railway Corporation on 19th of April. If I may kindly quote the letter, the wordings of the letter: the contractor has failed to execute work as per contract condition. The above contract has been terminated. In consequence of termination of the contract, Metro Authority has approved forfeiture of the BG. Now, my lord, this Metro Authority has approved. The approval has also been sent to us, which is dated 18th of April. That approval says that completion report has not been extended. However, BG has not been extended by the firm till date to cover the extended period of completion. Now, after receipt of this, my lord, the bank sends an email to
We have not extended the bank guarantee.
Yes,
It has been
page
extended.
819 and 820.
Yes, my lord. These facts are just relevant because the bank, as a bank, my lord, my client has not invoked the bank guarantee. Rather, we have written to the Metro Railway Corporation that your ground of termination is that the BG has not been extended, but process of extension of BG is already underway. Now, if you please let us know further instructions, whether we want to invoke it or you want to terminate the process of invocation of the BG. This mail we've sent, my lord. I just want to put this mail on record. Okay. May I hand over this, or may I, my lord, kindly file a supplementary affidavit? An affidavit.
The affidavit of service indicates that the answering respondent,
Number 2,
being the Metro Railway, Kolkata, was served the writ petition by mail on 8/5/2023 and thereafter by hand on 9/5/2023. Stop. The petitioner is given leave to affirm the affidavit of service in the course of the day. Stop. Next, the petitioner seeks interim relief with reference to a letter dated 19/4/2023, which is in the nature of, which is a letter by the from the Metro Railway to the respondent number 3, Axis Bank, respondent number 2, Axis Bank, calling upon the latter, 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 to invoke the bank guarantee, to encash the bank guarantee furnished by the petitioner, dated on 11/4/2022 for an amount of approximately rupees 2.90 crores. Stop. The petitioner has challenged the invocation on several grounds. Stop. Next, the first of such grounds is that is a sequence of letters written by the Metro Railway to the petitioner on 17/4, including on 17/4/2023, being a show cause notice for asking the petitioner giving the petitioner 7 days to commence work, failing which the petitioner's contract with the Metro Rail will be terminated. Metro Railways will be terminated. Stop. The other letter is of 24/4/2023, which gives the petitioner, gave the petitioner 7 days to 48 hours to commence the work, failing which the contract will be rescinded, and the impugned letter of 19/4/2023 invoking the bank guarantee. Stop. Learned counsel appearing for the petitioner submits that the letter of invocation was issued prior to the opportunity given to the petitioner to commence the work within 48 hours by way of the letter dated 24/4/2023. Stop. Council further submits that the impugned letter of invocation is not in terms of the bank guarantee furnished by the petitioner on 11/4/2022. To any alleged loss caused to the government, which in this case is the respondent number 1, above considerations persuade this court to grant interim protection to the petitioner until the respondents, including the Metro Railways, are given an opportunity to present their respective cases by way of affidavits. Stop. Next, the affidavit in opposition by 9th June. List this matter on 20th June 2023. Stop. The petitioner is to communicate this order on the Metro Railways in the course of the day. Stop. The Metro Railways shall be at liberty of approaching the court before it may be relevant to mention that the bank guarantee has since been extended till 31/7/2023 with the claim period till 31/7/2024. Stop. This is a specific submission made on behalf of the petitioner.
But this is an annexure also.
This is only for the relating to the township of Chittaranjan. That is the restricted, my lord. It is relating to the, my lord, Chittaranjan Locomotive Workshop Township, my lord. That's why PIL is,
Doesn't matter. What does the petitioner, what is the grievance of the petitioner?
my lord, grievance part, most of the grievance has been mitigated in the meantime. Only the representation is, I have made the representation to the authority, that is, my lord, Deputy General Manager. At this stage, if they consider the representation, I think
Where is the representative? What have
that
you
is,
asked
my
for?
lord, my lord. That is at, my lord, page 88 onwards. Page 88 and last representation, that is at, my lord, the petitioner made, my lord, that is page 94. Page 94. That's the representation.
What have you asked for? I can't follow. What have
My
you
lord,
asked
the
for?
representation, my lord, I am reading it, my lord. The above amendment in bylaws violates the provision contained before that it's required to be read. In the document minutes of meeting in which only administrative officer and chief wardens were present.
Saying of our constitution ab initio. What does it? Who is our? Who is our? Who are you? Who are the petitioners before the court?
Petitioners are the, my lord, they are the allottees of the quarter of the Chittaranjan Township, and they are the voter, and they are the vice warden of the committee. The committee has been prepared. They are the vice warden, and that's why they are the.
I can't understand. Committee for what?
My lord, committee is, my lord, committee.
You're not even ready in your matter. What are the facts?
My lord, I am.
You representation consideration that is not for the asking.
No, I am submitting the fact of the case, my lord. Fact of the case is, my lord, in the CLW Township, there is an area committee to control over the CLW Township. It is like the semi-municipality, my lord. Semi-municipality.
Yes. What?
There are a number of quarters in the area, and they have bifurcated the areas as area committee. So they are continuing to hold election for representative capacity persons who will look after the welfare of the
the petitioners say that the residents of these areas / staff, officers and employees of the CLW administration, elect their representatives as street members, quotation marks, paragraph 2 te peje jabe, for a member for 5 years, and the elected street members thereafter elect the vice warden. Stop. Each of the area committees is headed by a warden and 2 assistant wardens nominated by the general manager. Stop. The petitioners are aggrieved by an amendment brought about, which page?
My lord, that has been, my lord, considered, and that grievance has been mitigated, your lordship, subject to
My lord,
lordship's kind sanction.
Received the instruction.
He
that
has
the
not.
Representation has just now. Lord, they have-
My lord,
they are
now my prayer,
handing
my
it
lord,
over.
before your lordship, the representation page 88, my lord, only women representation, and from the minority community representation in the election, only this prayer, let them consider it, nothing more, my lord.
After this, my lord, possibly that will not.
Page 88
be-
representation from the women representative has been made, my lord.
Anyway. my lord,
That part has been considered, my lord.
What is the date of the representation at 94? What is the date of the representation?
My lord, the date of representation is, my lord,
3rd May 2023.
Very well.
yes. And
The
now-
the only last ki bola? Brought about by CLW. CLW for what?
My lord, for such ensuing election, area committee bylaws has been.
For the ensuing elections, ensuing elections pertaining to the area committee
Of CLW township.
of the CLW township. Stop. Next, learned counsel appearing for the petitioners refers to several representations, the last of which was made to the general manager, CLW on 3/5/2023. Stop. Next, learned counsel appearing for the CLW hands up a document of 9/5/2023, which has responded to the representation and clarified the issues made in the representation. Stop. Next. Since the petitioner's representation, last representation has already been addressed, nothing further remains in the writ petition. Stop. WPA 11398 of 2023 is accordingly disposed of in terms of the.
My lord, only one indulgence, my lord, the only women representation that is there, page 88, my lord, and the minority committee that may be considered, and they may pass a resin order.
No, that is not considered, that is not part
No,
of.
no, that has not been considered.
Very well. Since counsel for the petitioner submits that the representation dated.
Page 88, my lord, that is 3rd May 2023, same date, and 89.
Yeah, since counsel appearing for the petitioner submits that the response of CLW does not consider the women and
minority community.
Women and minority committee representation,
In the said election.
CLW is directed to consider this part of the representation and dispose it off with the decision communicated to the petitioner by.
By my lord, before the election is 14th instant.
My lord, the principle is same. It is
elect-
the women representation, that is the
By
representation.
7 days from date, within 7 days from date.
Correct,
Next,
Your Lordship.
next,
But that.
next.
All right.
নামগুলো দিয়ে দেবেন।
Hey, নামটা দাও।
Item number 23.
Milord, before Mr. Thakkar, Milord, starts his reply, Milord, may I humbly pray for an indulgence, Milord, of citing one judgment, Milord, on behalf of insurance company. It's on the question of disputed facts, Milord. When there's a question of disputed facts, Milord, the division bench judgment of this honorable court, Milord, I'm just handing over a copy to him, Milord.
Yes.
My Lordship, Milord, may I just hand over a copy to the Lordship, Milord? It is the last but one paragraph, Milord. The division bench judgment of this honorable court, Milord, passed last year, Milord, but the division presided over by Honorable Chief Justice, Milord. This is Prakash Srivastav. Milord, will kindly come, Milord, to paragraph 11 of this judgment.
You're the insurance company.
Lordship. Milord, the Honorable Single Bench, Milord, rejected the writ application, Milord, of the petitioner, in short. Milord, they preferred this appeal. And Milord, in this appeal, Your Lordship will kindly come, Milord, to the Milord, coming to the operative part, Milord, paragraph 11.
Yes.
Milord, the Honorable Division Bench, Milord, stated, Milord, a perusal of the repudiation order dated 8th of March. Milord, in this case, Milord, the claim was repudiated. A perusal of the repudiation order dated 8th of March 19 reveals that the claim of the appellant has been repudiated on the ground
What is the repudiation order?
Milord, in this case, Milord, the judgment, what I'm saying.
What is the repudiation? There must be a reason for you to cite this case.
Milord, the point is the question of facts, violation of policy conditions. That is why, Milord, even after getting the surveyor's report, insurance company repudiated this claim.
Please, I don't want your facts. Just what does 11 say? How does it help you?
Milord, it's a question of disputed facts, Milord.
Where does it say that?
Milord, it is there. Lordship will kindly see, Milord.
Yes.
I was only on the first line. A perusal of the repudiation order dated 8th of March 19 reveals that the claim of the appellant has been repudiated on the ground of violation of the policy condition 1, 3, and 5. Issue, if the appellant had violated these conditions, requires factual inquiry. Therefore, Writ Court has not committed any error in dismissing the petition on the ground that it involves disputed questions of facts. So far as the submission of the counsel for the appellant, the surveyor has found insurance company liable for payment and also the judgments relied upon by him in support of the surveyor's report. We are of the opinion that merely on the basis of the surveyor's report, insurance company cannot be held liable without considering other factual and legal aspects. Hence, we leave the issue of liability of insurance company open for the decision by the.
Yes. So how does this help you? How is it similar to the facts before the court?
Milord, in this case, Milord, the case before Your Lordship, Milord, there are disputed question of facts. Milord, I say, Milord, I rely upon the Milord, the contractual Milord obligations which has been imposed upon me. My London friends, Milord, is interpreting it in a different manner. Milord, I say that you give me the NOC. What you have asked me, Milord, what other co-insureds are asking me, Milord, to give. And Milord, one of the Milord, the respondent number 2 is not giving that NOC. Milord, I'm in a difficult position, Milord, because of the contractual obligation, what has been imposed upon me. I'm supposed to get NOC from my London friend, as well as, Milord, from the ONGC, which has not been made a party. ONGC has been very specific, Milord. I have shown that letter to Your Lordship, that they have got NOC, they are giving NOC to insurance company for making payment. But, Milord, they also asked me to get NOC from, Milord, AFSCONS.
Very well. That's all. Mr. Thakkar.
My lord, may I first address the argument of the insurance company, my lord? Wholly malafide and duplicity in the stand, my lord. The vessel was a total loss.
Mr. Thakkar, would you mind just waiting for 5 minutes so that I can finish one or two short matters?
Please.
Yes, call on the next matter, please. Thank you.
Not.
Item number 24.
Yes, I appear on behalf of the petitioner, Milord. They will challenge to the LOC, Milord. Initially restriction on traveling, then Milord sorted out. One of the petitioners were permitted.
Oh, this is not the one. Call on the next matter, please.
Milord, the hearing concluded and written notes.
Please wait. Next.
Item number 25.
I beg to appear for the petitioner in this matter. The petitioner has challenged an order passed by the respondent authorities, Lord, by which the bank has been directed to.
New matter?
No, Lord. Direction for affidavit, Lord. In spite of that, they have not filed. Cost was imposed also, Lord. Now, Your Lordship directed Mr. Doctor to.
On previous occasion, Milord, Your Lordship was kind enough to pass a direction to Milord to take instruction on this regard. And Milord, I have seen, Milord, I have gone through all the orders. Your Lordship was pleased to, Milord, the imposed cost, Milord. In course of the day, Milord, that would be filed because, Milord, we are in time. So far as the deposition of cost is concerned.
No, in any case, you will have to give the costs. Once it's there in the order, you will have to pay it.
Yes, Milord. Yes. In course of the day, that would be deposited. Milord, so far is the Milord, the fact of the case is case.
No. Have you filed your reply or not?
No, Milord, on that day, Milord, it was our Lordship's desire that today, my lord, we will file, my lord, our, my lord, the instruction only, because your lordship desired this, my lord.
There are earlier directions on you to file the reply. What are you saying, Mr. Dotto? Have you filed your reply or not? Otherwise, I will impose more costs on you today.
My lord, kindly see the previous order, my lord.
Sorry, I'm just giving you time to file it by Friday. Yes. Learned counsel appearing for the state. It is evident from the submissions made on behalf of the state that the reply, that the affidavit in opposition, which was directed to be filed since from
August 26, 2022.
My lord, none appeared on behalf of the state respondent. Your
from
lordship was
1/8/2022 is still not before the court. Stop. The orders in the file indicate that this fact was recorded several times thereafter. The fact of non-filing was recorded several times thereafter. Stop. The state was given one last opportunity to file the affidavit in opposition by the order dated 11/4/2023. 11/4/2023 upon payment of costs. Stop. Next. Council submits that the costs will be paid in the course of the day. Stop. List this matter on 15th May 2023. Stop. The affidavit in opposition should be filed by 12th May 2023. Yes, call on the next matter, please.
Item number 26.
My lord, I appeal for the petitioner, my lord. This is, my lord, the challenge, my lord, to the, my lord, request issued, my lord, for
lookout circular. Wait, next.
My lord, I would be, my lord, praying lordship fixes it for hearing, because I was only, my lord, required to, my lord, submit today whether, my lord, I would be praying for an interim relief. Affidavits were otherwise complete.
So in June, tell me a date, please.
My lord, in June, my lord, second week of June, any day, my lord, convenient to the bench.
Yes, list this matter on 13th June 2023 as prayed for.
I'm grateful,
Yes,
my lord.
next.
তারপরে কি next? Item number 27.
27, my lord, I appear on behalf of the private respondent. Lordship might recall there's a dispute.
Yes, I remember.
So, my lord, I placed on record the proposed settlement and also, my lord, the written notes on argument as desired by the court. Today, they were supposed to inform the court, and Lordship has seen that
Who's the petitioner?
Mr. HON'BLE was appearing. Lordship has engaged him, my lord, and I thought, my lord.
Yes, thank you, Mr. Dev. Yes.
Lordship.
Yes.
She wants to personally deal the matter, Lordship.
Sorry?
Client wants to personally conduct the matter, Lordship.
Then you have to come back in June. I will not hear you now.
Lordship.
All right, in June. There is no hurry. Yes. What is it that you want to say? You have a lawyer. I can't hear you. Microphone, please.
আমার লয়ার আমার সঙ্গে কোনো রকম সহযোগিতা করেননি এর আগে 4 তারিখে যেটা আমার মত আছে বলে
প্লিজ আই ক্যান্ট হিয়ার ইউ
ওকে আমি মাই লর্ড আমার উকিল আমার সঙ্গে কোনো রকম সহযোগিতা করছেন না 3 তারিখে আমাদের সন্ধ্যাবেলা যে প্রপোজাল লেটার অপোনেন্ট পার্টির থেকে আমরা পাই সেই লেটারও উনি আমায় দেননি 5 তারিখে সেটা দেন কিন্তু 4 তারিখে আমার মত আছে বলে সেটা এখানে জমা হয়ে যায় ওনাকে বারবার আমার কথা বলতে বলি উনি সেটা বলতে রাজি হন না ওনার মা বলেন যে প্রাপ্য টাকা নাকি 20% তারা পাবে এগুলো সব ফোনে ওভার আমি রেকর্ডিংও রেখেছিলাম অনেকগুলো তারপরে আমাকে এনওসি আমি যখন বলি এভাবে আমার মামলা মুভ করলে হবে না আমার থাকবার জায়গা দিতেই হবে ম্যাম যেটা বলছিলেন ওটাই আমার চাই তখন উনি মুভ করতে চান না আমি এনওসি চাই সেটাও আমাকে দিতে উনি অস্বীকার করেন আমার তাই জন্য কোনো উকিল নেই ম্যাডাম আমি আমার 4 লাইন একটা বক্তব্য আমি আসতে পেরেছি এখানে আপনি যদি একটু বলতেন
I will not give you any interim relief. You will only have to appear through a lawyer, or then you give your you release your lawyers, and then I will hear you in June. Yes, Mr. Dev, what is the problem?
I do not know. I do not know. I tell you, Lordship, but last day what had happened after
Because Mr. Paul was requested by the court to appear and
absolutely.
assist.
I tell you, Lordship. I tell you, Lordship. On the last day, I submitted that I called everybody. Petitioner was there to my chamber.
And Mr. Paul had no business. It was in fact the
Absolutely,
court requested him.
absolutely. I spoke to Mr. Pal also. I have given them a proposal. I said one-time settlement. I have put it on record. I thought, my lord, the way discussions had happened in presence of the advocate on record of the petitioner, Mr. Paul was not there, that the settlement would materialize. Somehow, my lord, what she's saying right now, my lord, that she has no faith in her lawyer. My lord, I have nothing to say. Lordship would seize the settlement, conduct rest. My lord, I cannot go into this. I have tried my level best to settle the problem. I thought they would agree. They would agree. I have given a reasonable proposal. I said I will
Very
bear.
well. Mr. Paul, what do you have to
What
say?
will I
Since,
say,
since
madam?
I have requested you to appear. Yes.
And I know
Your lordship directed me to assist the advocate on record. If advocate on record is changed, lordship, then I have to release lordship. She will conduct her matter of her own, or she will engage another lawyer.
And not only one thing regarding what has been stated today, that her learned advocate has said that she is agreeable to the proposal. That was never said by Mr. Paul or anybody. Never ever.
No, no, I
That's
don't
a-
remember Mr. Paul saying that
Never.
anyway.
I only proposed
Yes,
it.
it is evident that the settlement proposed between the parties through the kind intervention of a learned counsel appearing for the petitioner and the private respondent has not worked out. Stop. The petitioner now seeks to appear in person. Stop. The petitioner also makes it clear that she is not happy with the terms, with the proposed settlement. Stop. This court is not willing to entertain the matter this side of the vacation. Stop. List this matter on 12th June 2023. Yes, call the Tirupati one, please.
Item number 23.
Please, Your Lordship, my lord. May I first deal with the submissions of the insurance company, my lord?
Yes.
First of all, my lord, there is no disputed fact involved. My claim has been admitted. Balance amount of 8 crores is payable. That is admitted by the insurance company. The insurance company only takes the defense of a clause in my charter party. The insurance company has not shown Your Lordship any clause in the insurance policy which mandates that I am required to submit an NOC. This is a fight between me and AFCONs, which is being taken advantage of by the insurance company. And the insurance company stand before Your Lordship is wholly malafide and suffers from duplicity. Tell Your Lordship why. Insurance company says that I'm entitled to seek a no objection from AFCONs. Well, the vessel ran aground. The wreck had to be sold. Well, if the wreck was sold, it would inure to the benefit of the insurance company because the value received from the salvage sale reduces my claim. So it would mitigate my loss. The insurance company permitted me to sell the wreck. I received 4 crores from the wreck, which I have appropriated, and they have adjusted it against my total claim of 12 crores under the insurance policy. At that stage, my lord, they do not require me to seek any permission from AFCONs or ONGC to sell the wreck, nor do they seek any permission from AFCONs or ONGC to give me credit of 4 crores. And when I make this point in the petition that this was sold with the blessings of the insurance company, with the express permission of the insurance company makes a false statement on oath that this was done without our knowledge. I'll just give Your Lordship the paragraphs. I'll not trouble Your Lordship by reading them out, but Your Lordship may kindly make a note of 2 paragraphs. Para 11 of my petition and para 6 of the affidavit in opposition of the respondent number 1. I've specifically stated the sale was with the permission of the insurance company, with their authorization, and they have disputed this fact squarely in paragraph 6 of my affidavit in opposition. And now, my lord, may I just show Your Lordship 2 documents of my reply, which would show how false their stand is before Your Lordship, my lord. kindly come to page 20, please, of my affidavit in reply. There are two affidavits, my lord. The one which is just styled as affidavit in reply on behalf of the petitioner. This is the affidavit in reply to the opposition filed by the insurance company. Your lordship kindly sees page 20, please, my lord.
Yes.
We would like
Yes.
respondent number 1. My lord, Transocean Marine and General Surveyors were appointed by the insurance company as their surveyor. Now, Transocean, my lord, does the correspondence on behalf of the insurance company. Kindly see page 20, please, my lord.
Yes.
This is an email dated 10 December 2021 from Transocean to me, and lordships kindly see the copy. It is marked to Oriental Insurance. In fact, all of them are Oriental Insurance. All the officers of Oriental Insurance, the respondent number 1 are marked in copy, and he's writing to me. We would like to inform you, without prejudice to question of underwriters' liabilities, to sell the vessel with e-auction through MSTC and on other e-auctioneer process approved by Messrs. Oriental Insurance Company. We request you to be proactive in the process, as you have given an indication on a special category local purchaser and he must participate in the auction. The disposal as salvage should be in line with the CVC guidelines. Please be informed there are other issues related to admissibility of claim, and we have requested insurance company to take legal opinion before settlement of claim, after salvage sale and receipt of VRC cancellation. The entire sale was conducted with the permission of the insurance company, my lord, to mitigate their liability under the insurance policy. And this continues, my lord, at page 19. I'm sorry, my lord, I'm taking your lordship back because the emails are arranged in that order.
Yes.
This has reference to a copy of email dated so-and-so. This is again, my lord, the surveyor appointed by the insurance company writing to me with copy to the insurance company. The ownership of the wreck is with Messrs. Tirupati Vessels, that is the petitioner. And DG Shipping is said to be actively pursuing for removal of wreck. And your decision to sell the wreck as is where is basis is a prudent decision, as now due to damages she would not refloat and nor can be salvaged. Your indication of base cost of rupees 5 crores appears to be reasonable. MSTC is also public sector and is governed by CVC guideline, and request them for e-auction adhering to rules of CVC. Our mail is sent without prejudice to question of underwriter's liability. That is a liability under the policy. Then, my lord, kindly see page 17. Now, my lord, when I receive the offer, I write to the insurance company that please allow me to accept this offer at page 17, please, my lord. This is my email of 16th March. Tirupati Vessel, my lord, writing to the insurance company. Request for confirmation of acceptance of H1 bid. This is to inform your good self that auction was floated today at MSTC portal and the H1 bid received is 4.07 crores. We request your good self to kindly confirm your acceptance before we may confirm the buyer for the same. And my lord, the response comes from the surveyor at page 18. Shocking stand of a public sector undertaking, my lord.
Yes.
Kindly see page 18. This has reference, this is the surveyor writing, my lord. This has reference to a copy of email received asking the insurance company for acceptance of H1 offer of rupees 4.07 crores. And then, my lord, they allow this claim to come through. Now, kindly see clause 10. I'm sorry, paragraph 10 of this letter. We can now finalize the report once we get the following documents from your office. The revised claim bill. So, my lord, the 12 crores, which was my claim for the under the insurance policy for the full amount, now has to be revised after giving credit for 4.07 crores. The information on sale with documents to prove that CVC guidelines were followed. Sale invoice, considering amount quoted and details about forfeiting invoice money, etc. Information to DG Shipping about the sale. Now, kindly see the last paragraph. It is requested to accept the H1 bid without prejudice to question the underwriter's liabilities, and claim will be settled as per terms and conditions of policy, and insured to act as if uninsured and take a decision. Similarly, they say that please go ahead and sell at 4.07 crores, submit us your revised sale bill and insurance claim, which we will process now. However, whatever is the liability for the balance amount, they reserve their rights. And I'm not on that because now subsequently they've admitted their liability for the balance amount of 8 crores under the policy. Whereas the stand of the insurance company in the affidavit in opposition, now that your lordship has seen these documents, kindly see their false stand at paragraph 6. I'm sorry, paragraph D at page 4, please, my lord. Subparagraph D at page 4. The affidavit in opposition filed by the insurance company.
Yes.
Avik Barua. Page 4, please, my lord. I say that upon coming to know that on 17th May 2021, in the cyclone Tauktae, the insured barge has been damaged. Respondent number 1 appointed a surveyor to carry out the survey and assess the loss. The insurance company approved the subject claim for rupees 8.04 crores. The petitioner was requested to submit the NOC from both the co-insureds, namely ONGC and AFCON, so that the settled amount could be disbursed to the petitioner. However, in the meantime, the petitioner has sold the damaged barge or wreck on its own without any approval from the insurer. This 8.04 crores comes, my lord, after reducing the claim from 12 crores to 8 crores, after giving me credit for the 4 crores salvage which I have already received. His approval comes much later, blatantly false. And when he says without any approval, because he knows that at that stage, he did not seek any approval from AFCONs or ONGC. Now, my lord, coming to the contention of the private respondent AFCONs, my lord.
Yes.
My lord, AFCON makes submissions that they are entitled to receive 2 crores odd from me on account of steps taken by them to arrest or prevent the oil pollution, my lord.
Yes.
This is their case, my lord. The issue before your lordship, as I had submitted on the first day itself, my lord, there are 2 policies. One is the hull and machinery policy. One is the insurance policy on the oil and pollution damage control, which is covered by the P&I club. So there are 2 insurance companies, there are 2 insurance policies. He has a claim not under the hull and machinery policy. He has not lodged any claim with the insurance company under the hull and machinery policy, which is for a different aspect, my lord, that is the hull and machinery of the vessel. His claim is under the P&I policy.
He's as in AFCONs.
I'm sorry, my lord, AFCONs.
Yes.
AFCON's claim is under the P&I policy, my lord. They have corresponded with the P&I club. The P&I club has rejected their claim. The P&I club has suggested some alternate means to them to pursue their claim. They are free to do what they want. My lord, if their contention is that I owe them monies, there's an arbitration clause in the charter party. They are free to, my lord, invoke whatever remedy they want. But they cannot hold up the monies which are receivable by me under the hull and machinery policy without showing, my lord, that they have any interest in the hull and machinery policy. The entire affidavit in opposition does not.
Their contention was, Mr. Thakkar, that they had to expend substantial resources for
Yes, my lord.
stopping or
oil pollution.
Yes, arresting that spillage. And therefore they need to get that money from you.
Yes, they need that money from me. My lord, what they did, my lord, was under discharge of their statutory obligations. Your lordships was shown, my lord, was shown the email at pages 56. Kindly have the email once at page 56. Only the documents which they showed, your lordship, my lord, I'm showing your lordship those documents only. Kindly see the affidavit on opposition of R2, my lord. Kindly see the emails at page 56, please, my lord. This is what was shown to your lordship, my lord. I'm sorry, my lord, 57 onwards.
Yes.
Your lordship was shown the email at page 57 and the portion in bold, my lord, kind attention, Shri Rajiv Agarwal, Managing Director.
Yes.
And it was told to your lordship, my lord, that this is an email from the government, the Directorate General of Shipping, Mercantile Marine Department, calling upon the petitioner to deal with the oil pollution. Because the petitioner did not deal with it, they were required to step in and do it on my behalf. Kindly see, my lord, kindly see the top of that page, my lord. Kindly see the mail from Anish Joseph, DGS so-and-so 2. Now, my lord, kindly see the second line of the 2 field, my lord, or the first line itself, the last email ID. Manoj Kumar at AFCONs. This mail was not addressed only to me. This mail was sent by the statutory authorities to AFCONs. And, my lord, the second line is all, the recipients are all of AFCONs. And now, my lord, your lordship kindly sees the subject. Now, let's see the subject of that mail, please, my lord.
Yes.
Subject, notice under section 356J of the Merchant Shipping Act.
Yes.
Now, my lord, kindly see section 356J. We may kindly have 356J. The Merchant Shipping Act. Page 175, my lord, subsection 2, please, my lord. I have only one book, my lord. I'm sorry, I'll just.
Yes.
Lordship sees the obligation, is of the owners and all parties interested in the vessel, which includes the charterers, to take steps necessary for prevention of oil pollution. So when my learned friend says that it was only my responsibility and not the responsibility of AFCONs, is incorrect.
Yes.
The notice was rightly issued by the directorate to the owner as well as all parties, which specifically includes the charterer. And the email was specifically addressed to the charterer.
Yes.
These facts should have been brought to your lordship's notice. Now, my lord, they say, which is neither here nor there, but this case to prejudice, my lord, if possible, that they have to recover monies from me. And that is why they withhold the NOC under the hull and machinery policy. Where do they go? As if they are absolutely distraught. A, they have a contractual right under the charter party to start arbitration. This money they have already withheld, my lord. They should have told your lordship that. Kindly see page 11. I'm sorry, page 19 of their affidavit in opposition, paragraph 11.
Yes.
To legitimize their withholding of my dues, my lord, and to adjust it against their purported claims, they withhold the NOC.
Yes.
Kindly see paragraph 11, my lord, at page 19, please, my lord.
Yes.
About 10 lines from the top. The petitioners have failed. Your lordship has that, my lord?
Yes.
The petitioners have failed to account for the sum incurred by the answering respondent towards measures taken by it on its behalf for prevention and safeguarding of the vessel from oil spillage, which was otherwise the contractual responsibility of the petitioners, thereby causing irreparable financial loss to the answering respondent. In such circumstances, the answering respondents cannot issue no objection to the petitioners unless the petitioners release the expense to the tune of 2.23 crores borne by the answering respondent on its behalf for the aforesaid reasons. I say that the sum of rupees 2.3 crores is rightfully withheld. My lord, he's already withholding 2.3 crores payable by him under my charter party. I say that the sum of 2.3 crores is rightfully withheld by answering respondent for various reasons as mentioned in the foregoing paragraphs. It is specifically denied that the answering respondent has wrongfully or illegally withheld the sum of rupees 2.46 crores payable by it to the petitioner on account of charter hire. So, my lord, AFCONS is liable to pay me 2.46 crores on account of charter hire. It withholds this money, saying that I will withhold this money to settle the oil pollution cost which I have incurred on your behalf. Then he says, I will also withhold the NOC unless you write off this claim of 2.46 crores.
Very well. So you are the owner, AFCONS is the charterer, supposed to give you money for the charter hire.
Yes.
Very well. Yes.
And now, my lord, he is withholding money for the charter hire. Now to legitimize his withholding, he wants me to
Yes,
write.
I've understood.
And this
Anything
is
else?
repeated in paragraph 12, my lord, also.
And there are two policies. One is for the hull and machinery,
Yes.
which AFCONS doesn't have a claim
Doesn't
on.
have any interest.
The policy which AFCONS as the charterer has a claim on is the other policy with regard to that
Oil pollution, my lord,
oil
which
pollution,
is- yes.
and which has an arbitration clause.
Which has an arbitration clause. The charter party
Yes,
has
yes, I've
my
understood.
dispute with AFCONS can be resolved in the charter party arbitration, my lord.
Yes. Anything else?
That is all, my lord. One clause of the, my lord, charter party was shown to your lordship to say that this is my obligation, but that is factually incorrect. Again, my lord, neither here nor there.
And 357J, the charterer is under an equal liability
Yes,
to.
ma'am.
Yes, very good. Yes.
Now, my lord, whether the charter party provides for anything else as to who is to bear the cost of the oil pollution is not the subject matter of dispute before lordship, my lord. That has to be resolved between me and AFCON in arbitration. But for that claim, the insurance company under the hull and machinery policy, my lord, cannot withhold money. Clause 18F, my lord, of the charter
No,
party.
that's Mr. Thakur, I've understood the matter.
Please. Note file करना है? Note.
Yes. When will you indicate your points? When?
Maybe file a short one-page note, all of us. my lord.
Just one page.
One
just
page,
the
not more
points.
than one page, my lord.
Yes. And with the page numbers,
Please,
that's
ma'am.
all. Yes. Heard learned counsel appearing for the insurance company and the petitioner. Stop. List this matter on 12th May 2023
Please, ma'am.
for council to indicate their short points.
Grateful, ma'am. Deeply obliged.
One page, please.
One page, man, not more.
Yes, call on the next matter.
But since I have already placed lines on two judgments which have already been forwarded to your lordship, my lord, so I will only indicate the citations, but not.
Only the citation and the relevant paragraph, that's all. Yes, next.
Item number 24.
The hearing was concluded, my lord. We had filed our written notes and argument
yes,
on the
yes.
last day, maybe for
Dekhi.
on 3rd of May, my lord.
Mr. Deb, sorry, I wanted to go to the other matter and
no, my lord,
therefore
absolutely.
went
No, no,
back to Mr. Thakkar's matter.
Absolutely, my lord, absolutely.
Yes. And the judgments which you have annexed to your note that have already been handed up
Yes,
before?
yes. I made a mistake, my lord. Lordship's view is
That's all right. That's all right.
4 judgments. I have annexed everything.
একটু দেখে নিও তো পিটিশনারের নোটের সঙ্গে 4টে জাজমেন্ট আছে এই 4টে জাজমেন্ট আমার যেটা মার্ক করা আছে সেটা yes a learned counsel appearing for the parties have handed up their respective notes in support of their arguments. Stop. Next, reserve for judgment.
I'm grateful to your lordship, my lord.
Follow the next matter, please.
Item number 28.
Please, your lord.
28 for the statement. I appear for respondent number 3. May I file my opposition, my lord? I'm led by Mr. Probal Mukherjee. He's out of town. Can it be taken up after the vacation?
Are you enjoying an interim order?
No.
No.
My lord, the election will be held very soon, my lord. Already the process has been started.
My lord, it is the entire proceedings is completely beyond jurisdiction.
No, Mr. Bhattacharya, what is the urgency? Why should I take it up this side of the vacation?
Not the functioning is going on. The ad hoc committee, whichever has been appointed, is
That
beyond
trust, this is a
jurisdiction.
trust matter.
Yes.
And have you filed a reply also?
Yes, I've served.
Very well. When is Mr. Mukherjee here? Why not any day next week or this week?
My lord, he's not here, my lord. He's out of station, my lord.
No. Before the holidays, when should I keep the matter?
He won't be back. After the vacation, he will be back.
Mr. Bhattacharya, you tell me whether you want to wait or you want to do it this side of the vacation. Then I will fix a date.
Well, my instruction is to do the matter. Whatever it is, I have to do the matter.
Very well. Then you come back on
At 2 p.m. May I come back?
very well. Come back at 2 p.m.
Oh, goodness.
Yes. I have assigned matters from 2, Mr. Bhattacharya. So you can come back either this week, tomorrow, day after, or
On 12th, my lord.
yes. List this matter on
Okay.
12th.
Lord, my learned friends has been tomorrow.
List this matter tomorrow. Adjournment is prayed for on behalf of which respondent is this?
Respondent number 3, my lord.
Respondent number 3 on the ground of counsel not being available. Stop. Next. Learned counsel appearing for the petitioners submits that there is urgency in the matter and the matter cannot wait till June 2023. Stop. List this matter tomorrow as prayed for.
Well, the affidavit be filed kept with the records.
Yes, the affidavit in opposition and reply, the affidavits in opposition and reply are kept on record.
Application item number 267.
Yes.
Please, your ladyship.
So the respond number 1, my lord.
Mr. Chidambaram, which matter are you here for?
Item 1, I'm told.
Item 1.
First application.
Item number 258, if I'm not mistaken. Huh? 68. 68, sorry. 60?
Mr. Banerjee, don't add to the confusion.
I'm sorry. my lord.
Yes, 267. Yes. Yes. So you are going to move, you're moving which one? The writ petition or the cans or which one?
Would your ladyship kindly see your last order? The last order is dated 17th of April, 2023.
Yes.
And after sorting out various applications, your ladyship was able to reduce the matter.
Affidavits
Short
in
copies.
affidavits in the writ petition.
Now, kindly see the last but one page.
Yes.
The interim order granted by the coordinate bench has admittedly lost its force for the above reasons. It can therefore be recorded there is presently no interim order. The writ petition is thus required to be heard on affidavits. Learned counsel appearing for the contesting respondent bank. The only contesting bank is the Bank of Baroda. Takes the point of maintainability of the writ petition under section 21A of the Banking Regulation Act on the ground of the disputes being contractual and entirely private in nature. Let affidavit on opposition be filed within 2 weeks. Reply if any, all that has been done. List this matter on 10th May for hearing the writ petition as well as the application being can number 5. Can number 5 is consequential on your ladyship taking a view on the writ petition. The writ petition itself prays for the RBI to appoint an auditor.
Mr. Chidambaram, microphone, please.
Yes.
So can 5 is your application
Can 5 is my application for your ladyship.
for appointment of an independent external
appoint an
auditor.
independent external auditor to assist your lordship in deciding the matter finally. But prima facie, if your lordship is satisfied with the writ petition and that actually there are no disputed questions of fact as I will show.
May I file the affidavit in opposition?
Yes, yes. You are for the Bank of Baroda.
Bank. We have filed an affidavit in rejoinder.
Yes.
If your lordship desires some assistance, according to me, an expert can be appointed, but it may not be necessary because on the facts that I will present,
Expert of?
An external auditor to assist.
No, that is your prayer. That is prayer A
That is prayer A of the writ petition.
of the can 5.
Can, yes. But that is only if your ladyship requires assistance, because if I'm able to demonstrate on the facts pleaded and the documents that there is that the dispute which the Bank of Baroda is espousing is a make-believe dispute, then your ladyship can come to a conclusion. But I will be very happy if your ladyship appoints an external auditor.
So prayer A is for assistance of the court. I thought that's the prayer which you are asking for.
Your ladyship is referring to prayer A in the writ petition.
Of the can 5. Of can 5.
Kindly see. An order be made appointing an independent external auditor.
Mr. Chidambaram, can you please use the microphone?
Yes, I'm sorry. An order to be made appointing an independent external auditor, etc., to examine the consortium loan documents and the propriety and legitimacy of the rate of interest, including additional and penal interest levied thereto by respondent number 1. that will assist your ladyship. What is the loan agreement and whether they have strictly adhered to the loan agreement. Now, this will arise if your ladyship requires the assistance. That's why we have filed this application. But if I can demonstrate on the documents, on the facts and the pleadings, that the dispute is really a make-believe dispute, and your ladyship can come to the conclusion that what they are doing is completely wrong to the loan agreement and the sanction letter, then your ladyship can decide the matter. But at any stage, if your ladyship requires assistance, this external auditor can be appointed. That is my...
Mr. Chidambaram, before you start, let me clarify one thing.
Yes.
That is, we are more or less at the cusp of the summer holidays, which is going to start from, we have one more week, essentially. So you can place your matter if you want to. But if you need, since I'm going to hear the writ petition, I'm hearing the writ petition, I would assume, and after affidavits, I would assume that you need a judgment either way. So that judgment may not be forthcoming before 19th of May.
That I understand. That I understand. But since your ladyship fixed the writ petition and the can, and I've come to argue the writ petition and the
yes.
Now, the very short fact, there's a list of dates, but your ladyship can come to the list of dates a little later.
Yes.
The issue is very short. I wanted to establish a medical college and a hospital. It's established, it's running in Durgapur.
Yes.
To which I applied for a loan from a bank called Axis Bank, 210 crore. This is an overview. So the point is very narrow, 210 crore. Once that loan was sanctioned to me, one other bank, the then Syndicate Bank, now Canara Bank, and then subsequently Bank of Baroda, wanted a share of the loan. Therefore, the loan was downsold to the two banks. So 210 crore was divided into 70 crore, 70 crore and 70 crore. All three banks became lenders for 70 crore. The original loan agreement was added a first addendum on one date and a second addendum on the second date. We are really now concerned with the second addendum, which is the loan agreement comprising all three banks. Where's that document? Now that second addendum, that is in volume 1, page 216. Volume 1, page 216.
I can put the can aside now for the time being.
For the time being, please keep the can.
Yes.
Because I'll have to still satisfy you prima facie.
216? Yes.
216. Now, this is the loan agreement as amended, as including the three banks. I won't read the whole of it. Addendum to the loan agreement. Axis Bank, Bank of Baroda, and Syndicate Bank. Syndicate Bank is now Canara Bank. Now, this loan is now downsold. Kindly come to page 221.
Yes.
Each one of them gets to lend me 70 crore, 221.
Yes.
And then particulars of interest. This is the issue. Kindly let me read it. The spread which shall be applicable to the initial spread, applicable up to the initial spread reset date, shall be determined as follows. Axis Bank will charge 9.95 plus a spread of 1.60. I'll come to what spread is. Total 11.55. No dispute. Axis Bank has never disputed this and continued to charge me 11.55. In fact, today it is reduced it to 10%. But that's a separate story. Syndicate Bank, 10, spread of 1.5, total is 11.50. Syndicate Bank, now Canara Bank, followed in the footsteps of Bank of Baroda and arbitrarily, according to me, raised the interest rates unjustifiably, but since then have settled the matter pending the writ petition and are now charging 9.1%. So kindly note, Axis Bank is charging 10%, Syndicate Bank is charging 9.1%, but of course, with a little story in between, they arbitrarily raised the rate to about 15 and they brought it down. On the settlement, they brought it down and they compensated me for the excess interest rate, which according to me, they had calculated.
Yes.
And on balance, since they are now charging 9% prospectively going forward, I did a gain-loss calculation. They have more or less given back the excessive interest rate.
Yes.
I believe it's further reduced to 7, but it's not in the pleading. I won't trouble you. So please take it as 9. Now, Bank of Baroda, now
Yes.
kindly see, 9 is the base rate, spread is 1.5, 11.4. Those 11.4 at one point goes up to 17.
Yes.
And I'm protesting. I said, you have no justification at all to raise it to 17.15. And now, after the matter has been heard by a coordinate bench, went up to the division bench, etc., etc., they have now written me a letter on 4th of March, 2023, 4th of April, 2023, pending the writ petition, offering to reduce the interest rate. It's a very deceptive letter. It's a very confusing letter. Offering to reduce it to 11.25, but reserving the right to add penal interest, add some other charges, and only from 19 September 21. Which according to me does not compensate for the excessive interest rate they have collected from me. So I'm rejecting that offer. All I'm pointing out is at this stage is, suddenly when the writ petition is about to be heard, they are willing to reduce it to 11.25 going forward, whatever reason, 11.25 going forward, but reserving a right to charge penal interest and charge other charges, which I'm seriously disputing from the day one. Now I'll have to explain to your ladyship what is spread. Now there is a master direction by the Reserve Bank of India, which explains all these concepts and which has been held by the High Courts and by the Honorable Supreme Court as statutory in force and enforceable in a court of law. Master directions are enforceable in a court of law. I'll come to the case law a little later. Now, kindly see the master direction. This is a separate compilation given last time of the master of RBI circulars, the separate compilation.
I don't think you handed up with that.
I remember, but I'll give you another set.
But not another. Yeah, I think this one.
Okay.
Have you already filed it, Mr. Chidambaram? A
Yes,
separate
this was
compilation?
handed over last time. And
Yes, yes.
Madam, this kind of. No. This is 86 pages. Give another copy. I can give another copy.
No, they will find it out.
Give the other side first. I'm sorry. Give another copy. We can give another copy, my lady.
Very well. Yes. मुझे बात करो. Yes.
No, no, I have got a copy.
Yes, these are the convenience compilation of the master circulars.
Master
Yes.
circular, master direction circular, and the new draft circular,
Yes.
which is a draft stage only on fair lending practices.
Yes.
That last one is a. You don't have a copy. You copy, please answer. And then now, Shami. Now kindly see. The master circular is issued first by the RBI, and then it is followed by master directions, which have been held to be statutory and enforceable in a court of law. Now, the relevant master circular, there have been a series of master circulars. The relevant master circular is item 1, July 1, 2015.
Yes.
At page 1 to 24. Now, kindly come to page 6, spread.
Yes.
Bank should have a board approved policy delineating the components of spread charged to a customer. It should be ensured that any price differentiation is consistent with the bank's credit pricing policy.
Yes.
2, your lordships may skip. 3, the spread charged to an existing borrower should not be increased except on account of deterioration in the credit risk profile of the customer or change in the tenor premium. Any such decision regarding a change in spread on account of change in credit risk profile should be supported by a full-fledged risk profile review of the customer. The change in tenor premium should not be borrower specific or loan class specific. In other words, the change in tenor.
Mr. Chidambaram, these are regulations or whatever. These clauses are with regard to what is to be done in relation to a spread.
the
But
banks,
what
by
is
the regulated
spread?
banks.
Yes.
By the regulated
What is the
banks.
definition of the word spread?
That's what I'm reading. This is what they're explaining what spread is.
Yes, says should not be increased except on account of deterioration, etc.
Spread
Those are
should
the
be-
conditions.
That is how the spread can be changed. Spread is the interest rate and the components of the interest rate. I'll explain
Very
in a
well.
moment.
Yes.
Now, the change in tenor premium should not be borrower specific or loan class specific. In other words, the change in tenor premium, etc. Then kindly come to next is master direction. It starts at page 25. Kindly come to page 27, interest rate framework.
Yes.
27, interest rate framework. Now over the page, penal interest, paragraph 5.
Yes.
Penal interest. Bank shall formulate a board-approved policy for charging penal interest on advances which shall be fair and transparent. The rate of penal interest shall be decided after taking into account incentive to service the debt and due regard to genuine difficulties of customers. The proviso does not apply. Now, your lordships may kindly note that the rate of interest was fixed based on what then was a base rate. Don't trouble yourself. Your lordship may accept my statement. I don't think they will deny it. Base rate. This was a prevalent practice from 2010. On 1/4/2016, which is the relevant period for us, RBI asked all banks to migrate to MCLR, marginal cost of lending of rate, MCLR, 1/4/2016. Now that is explained in chapter 3 at page 28.
Yes.
Kindly see base rate. All floating rate rupee loans sanctioned and renewed between July 1, 2010 and March 31, 2016 shall be priced with reference to the base rate, which shall be the internal benchmark of such purposes. 3, there can be only one base rate for each bank, etc., etc. Then B, we are now governed by this regime. Marginal cost of funds based lending rate, MCLR. All floating rupee loans sanctioned and renewed with effect from April 1, 2016 shall be priced with reference to the marginal cost of funds based lending rate, MCLR, which will be the internal benchmark for such purposes, subject to the provisions contained in paragraph 7. The MCLR shall comprise of marginal cost of funds, negative carry on account of CRR, please don't trouble yourself with that, operating costs, and tenor premium. The tenor did not change, please don't trouble yourself with that. So it's the marginal cost of funds of the bank plus the administrative and operating cost of the bank is what the MCLR. Then marginal cost of funds is explained. Over the page, operating costs are explained. All that is explained. Then kindly come to page 32, spread. Banks shall have a board-approved policy delineating the components of spread charged to a customer. The policy shall include principles to determine the quantum of each component, to determine the range of spread for a given category of borrower, to delegate powers. Spread under base rate system. We are no longer concerned with base rate system, so I can skip A. But just to read one, the credit risk premium charged to an existing borrower shall not be increased except on account of deterioration in the credit risk profile of the customer or change in tenor premium. That is the same your ladyship read in the master circular. Then spread under MCLR system. In addition to the conditions laid down in section 8A of these directions, banks shall adopt the following broad components of spread. The component shall be arrived at taking into consideration the business strategy, market competition, embedded options in the loan product, market liquidity of the loan, etc. Credit risk premium. The credit risk premium charged to the customer representing the default risk arising from loan sanction shall be arrived at based on an appropriate credit risk rating scoring model and after taking into consideration customer relationship, expected loss, collaterals. The spread charged to an existing borrower shall not be increased except on account of deterioration in the credit risk profile of the customer. Any such decision regarding change in spread on account of change in credit risk profile shall be supported by a full-fledged risk profile review of the customer. This is the same as the master circular, provided that the stipulation, etc. Spread under external benchmark. The Lordship may. Then reset. Bank shall have the option specify interest reset dates on their floating rate loans. Bank shall have the option to offer loans with reset dates linked either to the date of first disbursement of the loan or to the date of review of MCLR. The marginal cost of funds lending rate, MCLR, prevailing on the date of first disbursement, whether partial or full, shall be applicable till the next reset date, irrespective of the changes in the benchmark during the interim. Future reset date shall be determined accordingly. The periodicity of reset shall be 1 year or lower. The exact periodicity of reset shall form part of the terms of the loan contract. The periodicity of the reset under MCLR shall correspond to the tenure, etc. Millard, shorn of all the jargon, what it means is you will take your MCLR and you will take into account the credit risk rating of the customer. It may be a exceptionally good customer with no bank default, etc. He will have the highest rating. But somebody who's new to the business or is defaulted once or twice, his banking history, all that is now available to every bank on the RBI website, the credit risk profile of every customer. You can reset the spread. Once the rate is decided, it cannot be reset until the reset date, as per the loan agreement.
Yes.
And you shall take into account market competition, saleability of the loan, etc. Kindly remember, this is not one bank lending me for the same project. This is 3 banks are lending me for the same project. Axis Bank was and is today the designated lead bank. Axis Bank has never departed from the original interest rate. In fact, it has substantially reduced it by almost 1.5%, 11.5 to 10. So obviously, as far as Axis Bank is concerned, my credit rate profile is not deteriorated, nor has any circumstance arisen which will require a reset of the rate to increase the rate. The reset can be in my favor also. In fact, Axis Bank has concluded that the reset, if it is to be done, in my favor. It has not increased it. Syndicate Bank did increase it from 11.5 to about 15, following the footsteps of R1 Bank of Baroda. But since realized, when the writ petition was filed, they have since realized their error, I assume. They have offered a compromise. They have offered a compromise and sharply reduced it to 9% from 2022. And I have calculated it, and it compensates, more or less, it compensates for the excessive interest. They have not thought it necessary today that my credit rate profile is declined so that the interest rate, then they sharply reduced it to 9, much lower than the original 11.5, almost by 2.5%. So as far as Axis Bank is concerned, my credit rate profile deserves an interest rate of 10. As far as Syndicate Bank is concerned, my credit rate profile deserves a rate of 9.1.
Mr. Chidambaram, I presume, or I can look a few paces ahead as to what you will say next, but just tell me what is the basis of the challenge?
The basis of the challenge is you have violated several conditions of the loan agreement. I'll give you one example. The loan agreement says the first reset date is 31/3/2018. You have reset it before.
Mr. Chidambaram, even if I were to agree with you,
yes,
and it may be justiciable on other counts, but is it a matter for Article 226?
Yes, that I've got a whole lot of case law. In fact, these very questions have been debated endlessly ad infinitum, High Court, Supreme Court.
No, maybe Mr. Chidambaram, but I will have to answer those questions.
Yes, yes. I'll give you a
no, that's why I want to just understand what your challenge is.
My challenge is, you're a public sector bank. You are governed by the master circular and master directions, which are enforceable. And I am relying upon the loan agreement and the terms of the loan agreement and how you've understood the loan agreement in setting the first first interest rate. You cannot reset it until 31/3/2018. You have done it before. You cannot charge penal interest over the spread, and I'll show that from their own document. You can't charge another 1% for deterioration of credit profile. I'll show it from his rejoinder. And these 3 things alone will show that he is with great impunity violating the loan agreement. He has to stick to the loan agreement. I'll straight away show the document. Kindly have volume 1, page 298.
And the other thing is, Mr. Chidambaram, how long do you wish to make your submissions? Because I'm sure that you don't expect a decision this side of the vacation. So what is just hear you and then put it in June? What do you want the court to do?
If your lordship, the ladyship will permit me the time, I can complete it today. I can complete my
Complete
submissions.
and complete within how much time?
What rises at what time? I'll try to go as fast as I can, but
No, Mr. Chidambaram, because I have my assigned matters on Wednesdays from 2 and from 3:30 I have my original side. That is why I want an idea how much time you will take.
require at least an hour.
An hour,
At
which is
least-
not possible today. So what do you propose to do?
I would request your lordship to give me a block of 1.5 hours
In June? Sure, certainly.
to 2 hours. And also give me the liberty, if necessary, appearing virtually.
Yes, of course. Why would you think that you will not be allowed to appear virtually?
No, I'm requesting because this has to be, I have to show documents. I'll try to appear physically.
And since I can't hear you properly physically, I'm sure I will hear you better when you're on the virtual platform.
Is it my voice or is it the microphone? I don't know.
Very well. So you tell me how much more time you want today.
Kindly, can I first clear the ground on the propositions? Give the other side a copy. Propositions that I will advance so that your lordships will get an idea that the legal objections are, the preliminary legal objections are
That the spread of the matter is not too much. That is what you want to say.
No, the point is master directions of, please read the 7 headlines.
Yes.
I've given the case law. Master directions of statutory force that has been held by the Supreme Court. Writ will lie against banks and financial institutions, including your lordship's court have held it. Writ will lie even in respect of contractual matters. Writ will lie even in case of disputed questions of fact. There are no disputed questions of fact, I'll show that. Section 21A, which my learned friend pointed out, of Banking Regulation Act. Kindly see the Banking Regulation Act, I'll show that. Is no bar to a constitutional court. It's only to a civil court. 21A says, please see the Banking Regulation Act 21A. These are, with great respect to my learned friend, in every bank case I've appeared, the respondent will always raise these objections. And every time these objections, we will cite these judgments. Kindly see 21A. Notwithstanding anything contained in the Usurious Loans Act or any other law relating to indebtedness and force in any state, a transaction between a banking company and its debtor shall not be reopened by any court on the ground that the rate of interest charged by the banking company in respect of such transactions is excessive. This does not apply to a constitutional court. They have held so. In a banking case, it does not apply to a constitutional court. So High Court and Supreme Court 226 cannot be curtailed. Your lordship, what is that? Chandra Chumar's case. Even a constitution amendment under 323A and B, barring the High Court from reviewing a CAT, they said no. Even a constitution amendment cannot take away our right under 226 and 32. Then court can appoint expert. Respondent cannot take advantage of his own wrong. He himself said what he will charge. He can't go behind that statement of his that I will charge only so much. Now, please very straight to see volume 1, page 298. That will cut down the controversy sharply. 298. Huh? No, that's 14.4.
Mr. Chidambaram, another 10 minutes. If you want some more extra time, then 15 minutes.
No, I'll just give the flavor of the dispute. It's not.
219? 219? What is the page?
Just one. Volume 2, page 298. Just see. It's not volume 1. 296, volume 2. Now, this is dated.
Yes,
Kindly come to 295, 5/1/2019.
yes,
Your Lordship will recall that the second amendment is dated 22/7/2015, which I showed it in volume 1, page 212. Bank of Baroda came into the picture from 22/7/2015. Apart from the other objections about reset, etc. This is what he said. The first reset cannot be before 31/3/2018. I will show that document today. It'll take 2 minutes. Then the next reset is in 2019. Now, please see this document. This is dated 5/1/2019 at page 295 and over the page at 296.
yes,
Facility, limit, sublimits, purpose, project cost, margin, rate of interest. Till compliance of the terms and conditions of original sanctioned applicable rate of interest on term loan. That is, he is presuming that there are conditions to be fulfilled. Till compliance of the terms and conditions of original sanction. Till perfection of security. Please mark that word. MCLR 8.65 plus SP 0.25. It's a special premium, plus 3.25%. That is a spread, plus penal interest of 2.2%. That is 14.15 as per circular number, etc., dated 24/7. The entire case turns on this. Please let me explain it. His MCLR is 8.65. Let's ignore the 0.25, some special premium. 3.25 is a spread. He's taken into account my credit risk profile, etc., etc. Plus penal interest of 2%. That is 14.15% as per circular so and so. Next sentence is important. Post compliance of the terms of conditions of original sanction, that is post perfection of security, MCLR 8.65, SP 0.25 plus 3.25, that is 12.15. It's quite simple, my lord. I'm not disputing his MCLR. I'm not disputing his special premium, whatever it is, that's a 0.25%. I'm accepting a spread for the time being, 3.25.
MCLR, you have said, what is SP you said?
SP is some special premium is charged.
Special premium.
We are not disputing it. I mean,
Yes.
it's too small a matter to trouble your lordship. We'll accept it for the time being. 3.25, I'll accept it for the time being. That is a spread. He says, if you perfect the security, I will charge you 12.15. He started with 11.40. He is now saying 12.15. Over the above paragraph says, if you don't perfect the security, I will charge you 2% penal interest. 14.15. According to me, he cannot. But for the sake of argument, let me accept 14.15.
Yes.
Let me be understood correctly, my lady. Let me accept for the time being, without prejudice, that is 3.25 is correct. His 2% penal interest is correct. So 14.15.
Yes.
What he's now done is, on 14.15, he is charging 2% for imperfection of security. I'll show from his reply.
Yes.
Imperfection of security is the reason why he's charging penal interest, and that is included in that fifth line Including that is 14.25. Once I perfect the security, it will come down to 12.15.
So is this under challenge in the
This
proceeding?
is what is under challenge.
So this is of 2019, 5th January.
No. There had been a dispute, then the negotiations, the writ petition was filed when?
In 2020,
21.
2021.
This has been a disputed, going up and down to the joint lenders meeting.
Yes.
Now, what he is doing is, after giving this commitment, 14.15 includes 2% penal interest for imperfection of security.
Yes.
The 2% will be removed once you perfect the security. He is now adding 2% to 14.15. Make it 16.15. That is the first grievance. Second grievance. First grievance is reset date. I'll show the reset date. Second grievance. Then he is doing something even worse.
Yes.
He says,
yes.
He says in his reply, imperfection of security, I don't admit it. There's no imperfect security. My security is far more than the stipulated security, but we'll take it for the argument. Imperfection of security leads to, the words, leading to deterioration in credit profile. So imperfection of security leads to deterioration of credit profile. Please remember, Master Circular says, if there is a deterioration of credit profile, you can add to the spread.
Yes.
He now says, I will add 2% over and above this 2% for imperfection of security. Although he says imperfection of security leads to deterioration, I will add 1% for deterioration of security credit. How many times can he count? So it becomes 14.15 plus 2% plus 1%, 17.15. How does he justify this?
So 17.15 has happened since when?
Since, my lord, I'll tell you, Lordship. There's a whole statement.
No, I'm just trying to understand your present worry.
17.15, he started charging in July 2019, after this document. July 2019.
Yes.
To April 2020. Then because the MCLR reduced, he reduced it, but he continues to charge this 2% penal interest. Now, may I just give this paper?
Mr. Chidambaram, let us end today, because you will not be
I
able
just
to
want to
complete.
one more page.
Yes.
Now, the first reset date is 31/3/2018.
First reset date.
I'll show that, and then volume 1, take my volume, page 81. So these are the three major attacks, apart from the fact that the consortium is seen reason, he doesn't see reason. Now kindly see page 81 about the sixth definition. Initial spread reset rate shall mean 31/3/2018. So he cannot reset before 31/3/2018.
Where are you getting that?
Page 81 about the seventh definition. Initial spread reset date. 31/3/2018. Page 81.
Yes.
There. And kindly immediately go to page 140 of the same volume.
Yes.
Yes. B, capital B 2.
Yes.
Up to the initial spread reset date, that is 31/3/2018, the applicable interest rate shall be base rate of the lender plus the spread. So nothing can be added to base rate and spread. Then lender shall have the option to review and revise the spread at the initial spread reset date and at each subsequent spread reset date. So the three-pronged attack is, you reset the interest rate before 31/3/2018.
Yes.
First complaint. Second complaint is, in January 2019, you told me immediately after the first reset date that I am including base rate plus special premium 0.25 plus spread 3.25 plus 2% because you have allegedly not perfected your security. Total comes to 14.15. And I clarify by saying, if you perfect the security, I will reduce it to 12.15. So the 2% is for imperfection of security. But what you are now doing is, for imperfection of security, you are adding another 2% to 14.15. How can you do that?
Yes.
That is the second prong of attack. The third prong of attack is, in his rejoinder, he has categorically said, imperfection of security led to paragraph 37 credit rate rating.
So, Mr. Chidambaram, what are you trying to save now? The penal rate of interest?
No, he can't charge me 17.15. And based on 17.15, he's adjusting the rate only because the base rate has come down. The cost of lending, cost of money to him.
No, so your grievance includes the additional 2% for the imperfection of security?
I'm not even accepting the first 2%.
Very well.
But
yes.
For the time being, keep it aside.
Yes.
I am not accepting the additional 2%. I am not accepting the additional 1%. Even if the additional 2% is right, if it leads to downgrading, how can you charge another 1%?
Very well. So the additional 2% plus 1%,
Yes.
that is your challenge?
Clearly illegal, clearly outrageously illegal. The 3% must go straight away.
Very well. So it is
14.1
restricted to 3% now, your challenge?
No, 14.15, I will challenge the 2% also, because penal interest can be charged only on the outstanding amount.
Very well.
That is the RBI. Penal interest can be charged only on the outstanding amount. What he has done is, he has charged on the whole loan amount. If I'm due any installment, if I'm due any interest installment or any principal payment, repayment installment, he can charge interest rate of penal interest. He is now charging on the whole amount. So that 14.15 is a separate argument. I'll keep it aside for the time being. I want to attack the egregious errors, defaults he has committed by adding 2% to 14.15, by adding 1% to 16.15 and making it a grand total of 17.15, when his own letter says 14.15. I will actually reduce it if you perfect your security. So really he can charge me only 12.15 because there's nothing wrong with the security. Axis Bank has accepted the security. How can the same security be imperfect for him and perfect for Axis Bank? The same security I've given.
Very well. Mr. Chidambaram, I've more or less understood you.
Your Lordship has broadly understood the attack.
I hope so, but I hope to remember when you come back in June or virtually. When do you want to do that, Mr. Chidambaram? It's an application, so it has to be on a Wednesday.
So please don't keep it on a Wednesday because we'll run into the same problem at 3:30. Your Lordships will have some other matter. Huh?
Sorry, it will be on a
that's
Monday.
3 days.
Monday.
Please keep it on a day where your ladyship can give me a little time.
No, it's I take up applications only on Monday. So any Monday you can choose.
Very well.
In June.
After what date? 3rd of June. Hmm? Yeah. 12th of June, Monday.
12th, yes. 12th is all right, Mr. Kaur?
Yes, absolutely.
Yes,
Your ladyship will kindly note it's parted.
I'm not sure I want to do that because I want to palm it off to some other court if I can.
I would humbly request. Now
I'm
that you're-
joining my learned friend, making a
and have-
request.
Yeah, we'll
Kindly make it parted.
kindly make it parted so that you can hear it on Monday.
Heard learned counsel appearing for the petitioners. Stop. List this matter on 12 June 2023. Stop. On the request made by learned counsel appearing for the parties, comma, this matter is treated as heard in part.
Lord, the affidavits, Lord, have been
Yes,
filed.
yes, yes.
So kindly.
The affidavits, the affidavit in opposition and reply have been filed in court today.
Much okay.
My volumes together. Obliged, Millie. Yeah, this one.
Call on the next matter, please.
Assigned matter, item number 268.
No, no, I'll take
For the respondent.
So if this is the matter of
Yes, yes,
ISI.
yes. Learned counsel appearing for the petitioner and the learned DSP appearing for the ISI have made over their respective, THEIR, their respective notes. Stop. List this matter. On 12th May 2023 under the heading for judgment.
I leave it.
Two 69.
Lordship, I am for the respondent number 2.
My lord, I appeal for the petitioner.
Yes.
My lord, the petitioner worked as administrative
Microphone, please.
finance officer.
I can't hear you. Microphone, please.
The petitioner worked as administrative finance officer. Uthabo. Sami nebo. The petitioner worked as administrative finance officer.
Yes, yes, I remember, Mr. Nondi.
Mr. Nondi.
Yes, yes, you were supposed to make your submissions today.
Yes, Lordship. Lordship, I am for the respondent number 2.
Yes.
Lordship, in that case, Lordship, the allegation was that the due process of law was not followed. But Lordship, if you see, Article 311 of the Indian Constitution, which clearly states that
1 minute.
Article 311, Clause 2.
Yes.
No such person as aforesaid shall be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of those charges. So, Lordship, by following this rule, director being the disciplinary authority, appoint an inquiry committee, and accordingly, that inquiry committee sent several representation to the petitioner to appear before that inquiry committee. But the petitioner, instead of appearing before the inquiry authority, he instead filed one and after writ petition before this, before the Honorable Calcutta High Court, Lordship.
Lordship, in the Rule 14, Sub-Rule 7 of the Central Civil Service rules clearly states that.
Have you given up, have you given a copy of those rules?
Lordship,
No, then you can place it and you can hand up a copy.
Lordship, I have just only one copy.
That's all right. Place it and then hand up a copy. Have you given a copy before?
No, Lordship.
Very well. Place it and give a copy in June. Yes.
Okay. Lordship, where it is clearly stated that the government servant shall appear in person.
What are you placing?
Sir, Lordship.
What are you placing?
Lordship, I'm making the submission that the in the Central Civil Service, so it is clearly stated that.
What are you placing? Just tell me.
Lordship. Central Civil Service, the Central Civil Service Rules 1965.
Very well. Yes.
Clearly stated that the government servants shall appear in person before the inquiry authority on such day and at such time within 10 working days from the date of receipt by the inquiry authority of the article of charges and the statement of imputation of misconduct or misbehavior, as the inquiring authority may by notice in writing specify in this behalf or within such further time, not exceeding 10 days as inquiry authority may allow. So, Lordship, in the bylaws, it is clearly stated that the person need to be appear before the inquiry authority within 10 years, but he doesn't comply with that. So in that proceeding, Lordship, he not even not cooperate with the inquiry authority, but he made allegation against the inquiry authority. Lordship, he made allegation against the inquiry authority. Lordship, kindly come to the page number 259 of the ABDB in opposition.
Yes.
251. Para 4.
Yes. Yes.
Para 4. Presuming that the charge officer not conversant with the court procedure might have been poorly advised, the inquiry recorded in the proceeding that mere filing of writ petition or pendency before the court cannot be bar on the holding inquiry, hoping that the charge officer would understand and rectify his mistake. The charge officer instead arrogantly reported in a language that sounded more as contemptible straight to the inquiry authority, saying, "You are hereby request to refrain yourself from making such unwanted communications, failing which I shall have no other alternative but to make you a party respondent in the pending writ petition." Lordship, in the writ petition also, the intention is totally clear. So, Lordship, kindly think, if he can certain the inquiry authority, then how he can behave with the other employee of the institution. So, Lordship, another thing is that he had filed one writ petition, number 2, WPA number 27725 or 2015, for setting aside the suspension order and staying the departmental inquiry till the disposal of the writ petition, where Justice Subroto Talukdar, after hearing of the both sides, dismissed the writ petition with the observation that, Lordship, in that case, kindly come to the page number 177 of the ABDB in opposition.
Yes. Yes.
The court further noticed that in WPA 1, the order of suspension dated 7 December 2015 was in contemplation of the disciplinary proceeding. The petitioner, in the absence of any interim order, cannot be permitted to settle the flow of due process, but not cooperating in the disciplinary proceedings and clinging on to the substantive allowance at his sweet will. The petitioner has not been able to demonstrate it before this court, in the light of the judicial authorities as adumbrated above, that the disciplinary proceeding is either without jurisdiction or is being carried out in violation of the principle of natural justice. On the contrary, this court finds adequate material with the records to show that the petitioner has avoided the disciplinary proceeding, which have reached their final stage, and even the second show cause issued to the petitioner waits his reply. This court noticed that instead of replying to the second show cause, the petitioner has taken recourse to one application after another to claim the sufficient allowance behind a smoke screen or being sent against the then sinning. In the backdrop of the above discussion, the court finds little merit in the emphatic plea of the petitioner that both.
That is all right. I have understood. what
So
the court
Lordship,
said. Yes.
Court also make it very clear that the disciplinary proceeding and the inquiry authority have the power to continue their proceedings. Lordship, in these circumstances, he didn't appear before the court, so before the inquiry authority. Then the inquiry authority, under this situation, concluded the hearing expertise and holding the petitioner guilty of the charges. Lordship, then, Lordship, finally, Lordship, Central Civil Service Rules, Rule 14, Sub-Rule 20. In that case, it is clearly stated that if the government servants to whom a copy of the article of charges has been delivered does not submit the written statement of defense on or before the date is specified for the purpose or does not appear in person before the inquiry authority or otherwise fails or refuse to comply with the provisions of this rule, the inquiry authority may hold the inquiry expertise. So according to that rule, inquiry authority concluded their hearing and found him guilty. Then Lordship, he appealed before the appellate authority, that is chairman, and that appellate authority also upheld the same decisions, and the executive council also resolved in its 81 meeting that the decision of the disciplinary authority found just deemed fit and proper.
Yes.
So Lordship, that's why the employee has been given compulsory retirement, Lordship, because he didn't even appear before the inquiry authority. That's why expertise hearing was concluded, Lordship.
Very well. You are appearing for the institute.
Yes, Lordship.
Anybody else who needs to be heard?
No, Lordship.
Yes. When is Mr. Nondi available?
Yes, my lord.
When is Mr. Nondi available?
Sir, Nondi could not come today because of personal reasons.
You should have said that right at the beginning. Why did you say that to the court? You should have said that when I called out the matter. I would have put it on some other date then. কবে থাকে matter গুলো দেখো. Yes. Learned counsel appearing for the institute has made his submissions. Stop. List this matter on 17th May 2023 for hearing any concluding submissions which counsel appearing for the petitioner may want to make. Stop. Yes, call on the next one, please.
$270.
Appealing for the respondent number 5.
Yes.
For the petitioner.
You had finished, Mr.
No,
Bandhavati?
I just formulated my points.
Yes,
Yes.
yes.
No, I will try to finish.
Yes.
When the writ petition was filed, we were not party in the writ petition.
Yes.
Therefore, not a single allegation has been made in the writ petition against our client. Although oral submissions have been made, factual submissions have been made against my client.
Yes.
But not a single averment is there against the respondent number 5.
Respondent number 5.
Yes. Not a single averment. We are not parties to the writ petition itself.
Yes.
We made an application for addition of party and then we have been added as party.
The paper book does not show your name. Page 5 of the paper book.
But in my paper book, it is there, Milord. Paper book is
Original petition add kora.
in the original petition, it has been written, Milord, pursuant to leave
Original
granted by the
petition.
Honorable Court, while allowing CAN 8953 of 2009, Messrs. Kultoli Food Marketing Private Limited. Necessary corrections, paper book correction to code. In the original.
Yes, yes. Original, you're
Yes,
there.
that's there. Well, therefore, whatever the allegations orally has been advanced from the bar,
Yes.
that's not substantiated by facts. Now, Milord, kindly come to state way, Milord. Kindly come to page. I will very kindly come to page, Milord. 81.
Yes.
This is the Milord, the advertisement vacancy notice.
Yes.
Milord, now kindly come to third paragraph of this notice. Now, therefore, it is notified for the general public that in superstition of the earlier notification, application is invited from intending self-help groups, stock registered cooperative societies, semi-cooperative society bodies, individuals, stock group of individuals as an entity for filling up the vacancy of distributorship in terms of clause 26(1) of the West Bengal Public Distribution System Maintenance of Control Order 2013 in Jamtala Hat at Kultala Police Station.
Yes.
Jamtala at Kultala in the district of South 24 in the Form G along with other requisite documents and treasury channels showing so and so in a sealed cover application for engagement for so and so in the district of 24 to the effect for food and so and so during working hours on any working day within 30 days from the date of publication of the notification.
Yes.
Well, this notification was published on 11 July 2019.
Yes.
13 days, Milord. It is 13 days. 11 July means 10th August. Time has expired for making the anybody's application.
No, 11 July means 10th August.
11 July up for 13 days.
Yes.
10th August.
10th August. Yes.
Milord, he filed the writ petition on 19th August 2019.
Yes.
Not before expiration, after expiration. They didn't file any application. Now, Milord, kindly, this main challenge is page 82, clause 5. The application must be financial solvent so as to run the distributorship business successfully, having bank balance of rupees 50 lakhs as working capital as reflected on the day of application and 1 year preceding the date of application. This is his challenge. So far, clause 5 has been declared to be bad. This is the reason that therefore here he is challenging for the self-help group. This clause 50 should not be there. Preference should be given there. This should be given to them. This is his challenge. This clause has come on the other day. I have handed over a notification that your lordships will find that from notification date 21st July 2014. কতটা আছে বল anyway Milord, kindly take this 97. Page 97 Milord, this has been কোথায় this page 97 affidavit reply no page 97 আমার সঙ্গে মিলছে না ভাই affidavit reply Milord, kindly take this one 110.
No, that is not part of records, Mr. Bandyopadhyay.
Pardon?
Is this not part of records?
Yes. No, this is 110, but this is statutory notification.
No. Just tell me, then I can mark it
Okay.
if it's part of
110,
records. 110 of?
No. Just a minute. Yes, 100 and 110. Of the paper book. Correct.
Yes.
Now, kindly see 110. Consequent upon issue of West Bengal Public Distribution amnesty order, while determining the eligibility of an applicant for engagement as a dealer, stock distributor, it has become necessary and expedient to adopt a suitable guideline in respect of the working capital, stock financial capacity of the applicants required for smooth running of FPS stock distribution insurance. Now, therefore, in exercise of the powers conferred under Section 3 of the EC Act 1955, and in cancellation of all previous orders and circulars on this subject, the governor is pleased hereby to make the following guidelines inter alia in respect of working capital, financial capacity at the time of filing application for engagement as dealer stock distributor under section 20 and answer to 26 of the West Bengal Public Dispute System. 1(2) is applicable here. Applicable for distributors must have bank balance of at least rupees 50 lakhs as working capital as reflected on the day of application and 1 year preceding the date of application. This 21st July 2014. On the basis of the 50 lakhs condition, 50 lakhs clause 5, that condition has been imposed. This notification has not been challenged.
Yes.
If this notification has not been challenged, well, any consequential order or action cannot be said to be bad. Secondly, one of the argument is that self-help group should get the preference. This was earlier the provision was that the preference should be given the self-help group. Now that has been amended. Amendment has been made. Kindly come to page 123 of the paper book.
Yes. Yes.
Page 123 of the paper book. Your lordships will come to last paragraph. For immediate reference, provisions of paragraph 26 of the West Bengal Public Dispute Maintenance Controller Act, amended by notification dated 18 December 2018, is reproduced here in below. The amendment was made on 18 December 2018. My lord, kindly come to next page, page 124, 2A. Your lordships kindly find, my lord, on receipt of the approval of the vacancy under subclause 1 or subclause 2, the concerned district controller food and supplies shall publish the vacancy notice in the official gazette, inviting the applications from self-help group, registered cooperative societies, semi-government bodies, individuals, group of individuals as an entity thereof, of specifying the eligibility criteria and the last date of receiving application. The district controller food and supplies shall simultaneously publish an indicative advertisement of the said vacancy for information to the general public and at least to local news transfer. But here, preference word has been deleted. Earlier, the preference word was there. Now, this amendment has also not been challenged.
Yes.
This amendment has also not been challenged. There were two on the 2 count. 50 lakhs said to be bad. It has been done on the basis of a statutory notification. That has not been challenged. Preference has not been given because of the amendment. That amendment has also not been challenged. 2 grounds, it's gone. Now, more emphasis was given to the earlier order of the division bench. The lordships kindly read this order. Kindly come to Miller. It starts from judgment in our matter. It starts from page 51. Lordships kindly come to this page which has been shown to your lordships. Page 70. Just a minute. Kindly read from 75. Last paragraph. Last paragraph.
Yes, Mr. Bandwat.
Now, kindly see page 75. This judgment was delivered, prior to amendment of the.
Yes.
Prior to amendment of the clause 26.
Yes.
Now, page 75. Kindly, it is last paragraph. It is not in dispute that the vacancy in question could not be filled up due to continuous litigations for the last 15 years or more. When the vacancy was declared initially in the year 2003, the control order of 2003 was enforced. The control order of 2013 came into effect from 8th August 2013. As per clause 26, Roman 2 of the new control order of if the district administration feels necessary to declare a vacancy of the vacancy shall be declared with the approval of the department. Such vacancy has to be widely published in the official notice board, official gazette, notification advertisement in the local as well as widely circulated daily newspaper. As per the 2013 control order, there is a provision for giving preference to self-help groups, special women self-help groups. In view of inclusion of the provisions for giving preference to certain groups, it implies that the zone of consideration of eligible candidate gets widened and the state gets an opportunity to select the best possible candidate for the purpose of distribution. Accordingly, the decision of the state government to invite fresh applicants for grant of distributorship does not seem to be arbitrary or unreasonable. The only pinching point is the issue of change of location of the distributorship. The vacancy at Jamtala Haat could not be filled up for a considerable period of time. Accordingly, the need to fill up the vacancy is very clear. Without any plausible reason to shift the location of distributorship, the action of the state is in shifting the locations maximum malafide and bias. It appears that the same had been done with the sole intention to favor a candidate who did not have its go down with the advertiser. Such action on the part of the state cannot be supported and is liable to be set aside. This action cannot be supported. This has been done. This is our appeal and state's appeal. Now, in view of the aforesaid facts, the impugned order of the learned trial judge is set aside. The advertisement and the vacancy notice published by the state 13 July 2000 are also set aside. The appropriate authority of the state government directed to initiate steps for issuance of fresh advertisement for filling up the vacancy of Jamtala Haat Mauja. In accordance with the provision of the West Bengal Public System Transfer, the advertisement and vacancy notice shall give a wide publicity in accordance with provision transfer. Later on, that Jamtala Mauja has been it has been deleted. Mauja, page 78, only that Jamtala Haat. It has brought in our notice or the applicant for correction of a mistake when environmentally the word Mauja that is appearing after Jamtala Haat. Therefore, this advertisement has been made.
Yes.
For the place, face advertisement has been made for the Jamtala Haat. For the purpose Jamtala Haat, I have shown the vacancy notice itself. Vacancy notice speaks about Jamtala Haat. This page 76 on 2 or 3 counts, this has been relied upon. First of all, preference. Second is all earlier vacancy notice have been withdrawn. This vacancy notice has not been withdrawn. Now, I have threefold submissions on this. So far, the preferential to self-help group is concerned, when the judgment was delivered, that time old law was there. When the advertisement has been made, because court has said, the Honorable Division Bench has said, in terms of the 2013 control order. Now, when the advertisement was made, amendment had been taken place. Therefore, they have to do it. And this Jamtala Haat, yes, pursuant to all the order of the division bench. Division bench has said you have to do it, Jamtala Haat. It is pending for long. So there's nothing wrong. If the other vacancies have the notification, in respect of the other vacancies have been withdrawn, if this notification has been kept alive because of the division bench order, they have to comply. Otherwise, there's a contempt. They have to do it. Therefore, this notification is there. Now, I am taking the preference word. What is the preference? Preference has been taken away.
Yes.
Amendment. Let me make my argument. Even let me accept his argument. What is the meaning of the word preference? Preference means all should be equal. If it is all equal, then the self-help group will be given the preference. That is the preferential. They did not make the application within 13 days. 30 days. Kindly mark it,
Yes.
If one has not made the application, demand of preference is one cannot seek for a preference. Second thing, preference doesn't mean the relaxation of the condition so far the preferred candidate is concerned. He is saying, this is according to their content, 50 lakhs should not be for the self-help group. How it can be? In a case of a reservation also,
Yes.
they must be equal. Then they reserve. There cannot be relaxation of the condition is concerned unless the statute makes such a provisions. If the statutory provisions is there, yes. But the main criteria cannot be relaxed. Just I am giving an example, an instance, that in case of ordinary, general candidate, age is 35. Scheduled caste reservation is there 10%, just giving a figure. Schedule class statutory law is saying statutory provision has been a relaxation for a period of another 5 years, 40 years. These are statutory provisions. If a statutory provision is there, no one can claim as a matter of right. Therefore, this is the judgment. There is no, one of the argument has been made, this vacancy notice has been declared, published in contravention of this direction, in contravention of the order. Miller, and the judgment has been relied upon. I will distinguish that. Miller, kindly see what is the direction? What is the direction? Direction has not been violated. On the contrary, as per direction, a vacancy has to be declared for Jamtala Hart.
Yes.
Miller, this is submission. Miller, another submission is this, Miller. Your lordships have marked it, Miller, that I have gone through it, that for longer period, this at place, one reason or another, it is stayed, set aside, is coming, Miller. We have given the details of that. And in our affidavit. First, it was moved, Miller. Your lordships will find, Miller. We have given it from page 33. No? Yes, 33. I have given the Miller. Page 33, your lordships will find.
Yes.
Miller, I have given the details, Miller. Just kindly just hear, because Miller, long.
No, 33 of the paper book.
33 of the paper book.
Yes.
Miller, background of this case. A vacancy notice for appointment of MR distributor at Jamtala Hart, Kaltari in the district of South India. In 2003, Miller, a notification was published. Miller, 5 writ petitions were moved. And this writ petition is disposed of by the honor directing publication of said vacancy notice in the official gazette. What has happened, Miller? That was the judgment of Justice Indira Banerjee. Miller, what has happened in the block development officer's office? An advertisement was given, and one Borun Ghosh. But this name is very important name so far this litigation is concerned. Borun Ghosh, who made the application? Advertisement videos office made the application. No one came to learn. Then we had to.
No one came to
learn about this notification. Only Borun Ghosh advertisement. Then we moved the writ petition that this notification advertisement should be made. It should be widely published. Justice Banerjee, Miller, Justice Indira Banerjee, Miller, my lord, as lordship, then was Miller set aside that and held it, Miller, that it should be gazette notification. Against that, Borun Ghosh went to appeal court. Appeal court dismissed it. Miller, then the second round. Now, Miller, Miller, just ignoring all recommendations. The Borun Ghosh was recommended. Then the second writ petition came. Second writ petition filed. Anyway, Miller, this learned single judge held it. That time, Miller, we moved the writ petition. No, a recommendation which was incorrect, not legally sustainable, that recommendation was directed to be given effect by one of the learned single judge. And that time, 2013 control order has come into the picture. Learned single judge said no 2013 control order. You have to go by the 2003 control order. Against that, we went on appeal. Appeal court has held it no in terms of 2013 control order. That time, Borun Ghosh was party. Now, kindly see, very importantly, my lord, kindly come to page 120.
So, appeal court judgment was in your favor?
Yes.
Yes.
Yes. Appeal court judgment was, against that, they went to Supreme Court. Supreme Court dismissed the SLP.
Yes.
That's that page, my lord. Just without page about Supreme Court. Your lordships will get it, page 79.
Yes. Yes.
Now, kindly come to page 121. Your lordships will find, my lord.
Yes.
Kindly similar.
Mr. Bandyopadhyay, you have to finish in 2 minutes because I haven't even been able to take my other.
Very nice, my lord. I just say, my lord, kindly take, my lord, take note of page 120
Yes.
and 121. Your lordships will find everywhere the Borun Ghost's name is there. This state affidavit. My lord, kindly come to just 121 K. It is relevant to mention here that in the meantime, the distributorship of Bharati Sen was transferred in favor of the daughter of Susmita Ghosh, wife of Borun Ghosh. And this said proposal was forwarded by the district controller of food and service so and so. Now, the crux of the things of the litigation is this. So long this vacancy will remain state, the wife of Borun Ghosh will enjoy. Because it has been linked with him.
No, what? If the vacancy is stayed, then how will the wife enjoy?
No. These vacancies, dealerships have been tagged.
Yes.
This is the tagged with this Susmita Ghosh. If the vacancy is allowed to work
So
on,
she's the existing distributor.
she is the existing distributor for different place.
Yes.
But since this Jamtala Hart
Yes.
is vacant, here all dealers have been tagged with her. The moment this will be given effect to, it will be detagged.
No, so tagged with her means what?
Tagged with dealerships have been tagged. What is happening? I just tell you. Say A and B. A is a distributor, B is a distributor. B expired. A is having 30, B is having 30. Dealer, right? B expired. Then these 30 dealers would be tagged with A for a temporary period. So long B, instead of B, someone is appointed.
Yes.
Because it cannot remain empty. Someone has to, they have to get it.
So you're saying that because of this stay, this wife of Borun Ghosh is enjoying all this?
Yes.
But that's what is the corroboration, Mr. Bandyopadhyay? What is the evidence of this?
This is the state's evidence. Lots of times this has been said. Okay.
Very well. And who is the petitioner before the court?
I am coming. Just a minute.
Yes.
Now, C. L. Borun Ghosh being the husband of Susmita Ghosh and existing MRD, wherein 19 dealers were proposed to be cartel, filed to do challenging the cancellation of earlier vacancies or so and so. Now, kindly see this. The writ petition has been filed by whom? Writ petition has been filed by
Shama Self-Help Group.
Shama Self-Help Group is the petitioner who has affirmed it. Kindly come to page 22. Indrani Ghosh.
Who is that?
Niece.
Apart from the surnames being similar, Mr.
No, that has been said in the affidavit.
Yes.
This is a fact, reality, ground reality.
Very well. You tell me, who is the deponent? How is the deponent connected to this Borun Ghosh?
Indrani Ghosh. I am coming, Miller. Kindly come to 143. 143 কি আছে? কোথায়? 4. 143 paragraph 4.
Yes. What is all this family business? What is all this?
No, there were self-help group. Self-help group is just a veil. Real face is Ghosh family. Self-help group is just veil. That's the reason I am showing it to you. Family business, I don't have the difficulties. Claiming self-help means the deserving persons. And it is not that, my lord, self-help group consists of male and female also, not only for the female. That is also their circular. Deserving person.
Very
Therefore, veil is this self-help group.
That is all, Mr.
My
Bandyopadhyay?
lord, just two judgments. Just
Mr. Bandyopadhyay, on the next day, not today. I have to touch upon the other
all right,
matters.
two other judgments.
Yes.
ठीक है, पढ़ देंगे आज.
Learned counsel appearing for the added respondent number 5 will conclude his submissions on 17th May 2023. Yes, call on the next matter, please. এই কাগজগুলো আলাদা করে রাখো। তো সমস্ত কাগজ আমার চেম্বারে নিয়ে যাবে করে এটাকে বার করবে, কারণ এটা আমার মনে আছে আগের দিন দিয়েছিল আমার। কোর্টে ডাকো।
Item number 271.
My lord, I beg to appear for the petition.
Mr. Das, how much time will you take?
Lordship, I'll take at least 20 minutes. I'll tell your lordship, the pleadings are voluminous. I have already given an outline of my submissions, but I have to show some of the pleadings, your lordship, to buttress the submissions that I have made. And this is a matter, your lordship, where the petitioners are protected by an interim order, the voluminous pleadings, and there are several other respondents who will be making submissions. Your lordship takes it up at your lordship's convenience on any other date. Perhaps it will-
No, only on the days when I'm supposed to take up these matters.
Yes, your lordship, then may I pray your lordship kindly takes it up after the vacation or on the next, I think there's another Wednesday before the vacation. I'll
Yes,
need
you tell
20
me either
minutes.
17th or 7th.
Lordship takes it up on 7th because even on the next date, there will be, my lord, urgent matters before your lordship. I'll take around 20 minutes of your lordship's time, not more than that. 7th also?
ওখানে নেই নাকি? Learned counsel appearing for the respondent number 7-9 will conclude his submissions on 7 June 2023. Yes, call on the next matter, please. Yes, all the Bishwabharati matters, I will take it up next week or in June.
But my lord, only.
Yes, Dako, matter. I can't hear you.
72.
I shall file the supplementary.
I can't understand.
Item number
Please.
272.
My lord, I want to file a supplementary affidavit incorporating the resolution which removed me.
So that is something which I gave you leave last day. What have you done?
That is in another matter. It is the 2002.
Very well. Learned
2072.
counsel appearing for the petitioner seeks to file a supplementary affidavit to bring on record subsequent facts. Stop. The supplementary affidavit should be filed by 7 June 2023 with an advance copy given to the university, capital U. List this matter on 7 June 2023. Next.
Deeply obliged.
Item number 273.
Still, Vishwabharati can taken next week.
Next week, very well, but next week, very little chance of all this, because next week I will not take these matters up from 2 o'clock. Yes, list this matter on 17 May 2023 as prayed for. Next.
Item number 274.
It is the matter of the registrar, my lord, the removal of the registrar.
Yes.
So, my lord, let it be kept on the, today your lordship is busy, let it be kept in the next week.
Yes, same order. Next.
No.
275.
Appearing on
Ma'am,
behalf of
appearing
the
for
petitioner,
state
your
lordship.
lordship. My instruction is the petitioner wants to move this application in person. And I want to tell your lordship one thing. On the last occasion, your lordship granted leave to the petitioner to add party to the concerned parties. Those formalities are done by her just because the erstwhile advocate on record has already given his no objection.
Who was directed to be added as a party?
Three personals, three Bandhan Bank officials.
Very well.
I appeal for the private respondents, the added
My lord,
party.
I just pointed out one thing.
1 minute. The petitioner seeks to appear and argue the matter in person. Stop. Learned counsel who was requested to assist the petitioner is hence given leave to retire from the matter. Stop. The court records its appreciation to counsel. Stop. Thank you, Ms. Roy. The parties who were directed to be added, the private respondents, in compliance of the direction, the private respondents have been added to the writ petition in compliance with the direction passed by this court on 26/4/2023. Yes.
From police report that has not been yet submitted to.
I can't hear you. Microphone, please.
My lord, one police report that was very old on March that has been under your direction has been shared with me, but that has not been submitted to court. I would like to submit that report of
I
court.
already handed it over.
Yes, yes, it's part of records. Yes. দেখি আমাকে আগের দিনের রিপোর্টটা দাও তো।
I don't.
এটাকে বেঁধে তোমরা কি মাঝে মাঝে ডকুমেন্ট গুলোর সঙ্গে এরকম মাঝে মাঝে আপলোড করে রাখো না? করো এটা। Yes.
My lord, in page number 15 of the police report, there is one name has been added, Sanjay Bhattacharya, who has taken a login of my Hotmail account.
Please,
Okay.
lower your volume, please. Page.
Page number 15, sir, madam.
Yes.
There is a name called Sanjay Bhattacharya, Sanjay B4, and his IP address is 100.
Which is page 15? There is no, it's not paginated. Which is page 15?
That is on the police record.
Lordship, maybe the page numbers are very lightly marked. I can just.
Page 15?
Yes, yes, my lord.
It's not paginated. How do I know which is page 15?
Lordship, the paginations are very lightly marked.
Yes, what is it that you want?
My lord, there is a one name has been already mentioned by police officer for Hotmail account login and multiple times login by Sanjay Bhattacharya. So I have also sent this copy that this is the police information that how you are linked to Bandhan Bank, because we have 10,000 employees. We do not know each and every person. And in my petition, I have already mentioned that without professional hacker, the mail ID cannot be accessed. The 36 character password cannot be decoded by a normal person. So I believe that he is working under instruction. And in police report also on the first page.
Working under instruction? Instruction from who? Bandhan Bank?
I do not know, madam, because
No,
it is written in the.
You are making a submission, so you will have to prove it.
Sir, actually, this is in police report, it is there. So that's why I want to highlight it, this matter.
So what? What is the relief you want?
That is, in police report, it is recorded that he is accessing my email ID.
What is the relief you want?
Sir, my lord, I want to add him also the party, because he and Ranjan Gangobadaya, Shormishta Goswami can be front to front interrogated by any of the authority as you may wish, so that how he has been, because I do not know, his address is Santoshpur. I stay in airport.
Where are you getting the name from?
The second paragraph, inquiry of police. Because there is no point that I can go to Santoshpur and log in from that.
Please find out page 15 and paginate it by 4:30, please. By 4:30, please paginate it.
Yes, sir. একবার দেখে নিন
হ্যাঁ, আমি
check
দেখে
করুন। রিপোর্টটা দেওয়া
এই তো দিলাম যে আগে report
Yes, but where are you getting the name?
Police written in second paragraph, collected reply from Microsoft nodal team. Microsoft nodal team has named this person, Sanjay Bhattacharya, BK Tower.
He's not named in page 15. Is he named?
No.
She's talking about the inquiry report. We have an annexed lordship that is at the first page. What she's now referring.
Yes. Yes, Sanjay Bhattacharya is where?
In second inquiry, second paragraph.
Yes.
And this is given by Microsoft nodal team.
Very well. So you want to add him? Very
Yes.
well, go ahead and add him. What else?
And my lord, then what police want to say that
Nothing. What do you have to say anyway? I'll just give you leave to add and I will take it up in June. Yes. The petitioner submits that the report submitted by the police submitted by the IC Cybercrime PS of 6/4/2023 mentions Mr. Sanjay Bhattacharya, B থেকে দেখে নেবে, who has been named by the Microsoft nodal team, capitals, as having logged in to the petitioner's mail ID Stop. The petitioner wants to add Sanjay Bhattacharya as a party to the writ petition. Stop. Next, it may be mentioned that the relevant paragraph of the report, capital R, also states that Sanjay Bhattacharya and his family members were preliminarily examined, and it was verified that they are not involved in any unauthorized access of the petitioner's mail ID. Not involved in any unauthorized access of the petitioner's mail ID. Stop. Next, lists this matter on 14th June 2023. Stop. The petitioner is given leave to add Sanjay Bhattacharya as a party respondent to the writ petition.
Supplementary file করেছেন?
না, এইগুলো শুধু ট্র্যাক রিপোর্ট।
ও আচ্ছা, সেটা দেখো। Great flush.
Okay.
Supplementary কোনো file?
Petitioner কি করে party? Yes, call on the next matter, please.
রিপোর্টটা দেবেন না, প্যাজিনেশনটা করে দেবেন।
Yes, that is all. Yes, original side.
আমি প্যাজিনেট করে দিয়ে দিচ্ছি। Great flush.
Yes.
এই এটা বাবু
Sure.
Your side, item number 1. This is HON'BLE Building and Investment Company.
My lord, I appear for the writ petitioner. My lord, on the last occasion, your lordship had, my lord, heard both of us, my lord, and asked us to, my lord, exchange the, my lord, citations. Because
Yes.
my learned friend had also taken a point of, my lord, on behalf of the Mutawalli had taken a point of, my lord, demurrer. My lord, but my lord, while, my lord, the matter is going on, and I was, my lord, assured, my lord, that this, since the matter is being heard out before your lordship, they will not take any steps in the meantime because your lordship, my lord, has not passed any orders as of now. My lord, we are, my lord, aghast, my lord, may I file a supplementary affidavit? They have, during the pendency of the writ petition and while your lordship is hearing the matter, has issued another show cause notice on the self-same building in respect of the same, my lord, work of property on 27th April 2023, now on my sublessee, who admittedly they know are my sublessee. My lord, this is, my lord, very.
Sublessee is a party to the writ petition.
No, my lord, I am the principal leaseholder. I have filed the writ petition. They know that they cannot proceed against, possibly proceed.
No
against.
interim relief. Sublessee is not a party.
My lord, but
Yes.
kindly see the way they are moving, my lord.
Your
Maybe-
ladyship will have the matter tomorrow. Mr. Rahim is in a parthead, my lord. That will get over at 4 o'clock. It's a humble request to have the matter tomorrow, my lords.
No. I've already started hearing. You should have made the submission first when I
My lords,
started. No.
There was
Sorry.
difficulty connecting.
Mute করে দাও তো. Yes. Yes.
Now, my lord,
My lord, I am appearing on behalf of the Board of Waqf.
now, my
Yes.
lord, my humble submission before
Yes.
your
Have you issued the letter?
My lord,
I may give a copy to copy the order.
But I'm not going to give you any interim
Sub-
relief.
That's
Subsequently,
fine, my
the-
lord, but this is, my lord, this should not be done.
Yes.
connected in this case?
আপনি তো নিজেই দেখুন না আপনার
না না
কাছে।
সেটা আমার কাছে ইনফরমেশন নেই।
আপনি সেম ওয়াক অফ এস্টেটে ইউ হ্যাভ ইস্যুড দিস
I have to take instruction.
এই দেখুন it's the same, my lord, walk of estate, same premises at page 6, my lord, they have issued this notice.
এজি কেন?
যা আছে আমার কাছে copy আছে।
Very well.
Easy-
Learned
easy-
counsel
easy
appearing for
cases
the
also
petitioners submits that the Waqf board has issued a notice dated 27/4/2023 to the petitioner's sublessee in respect of the same premises. Stop. Counsel accordingly seeks to file a supplementary affidavit containing the relevant document. Stop. The supplementary affidavit is taken on record. A copy of the supplementary affidavit shall be filed, shall be served on the Waqf board as well as the Mutawalli. Stop. Yes, what do you want to do about the remaining submissions?
Now, my lord, the remaining submission, I have already made my submissions. My lord, I have said, my lord, that a prior civil suit has been filed by the Mutawalli himself for my eviction.
Yes,
That suit is pending.
yes.
And I have, my lord, taken out an application under Order 7, Rule 11, saying that the civil court does not have jurisdiction because this is a, lord, Thika property. Thereafter, my lord, the petitioners before your lordship has filed an application before the Thika controller, has filed the forms, and the process before the Thika controller is in session. The Thika controller has issued a notice in terms of the act for determination whether the property is a Thika property or not. My submission is, when the Mutawalli himself has approached a civil court asking for my eviction, matter is pending. It's not that the petitioner has gone to a civil court. The Mutawalli himself has gone and approached the civil court and the matter is pending. I have gone to the Lord Thika controller saying that the property is under Thika controller's act and that this is a Thika land. That determination is pending. The Waqf board under section 54 of the Waqf Act, which is a summary proceedings, cannot suo motu issue a notice for my eviction when the Mutawalli himself has gone before the civil court. There's a clear bar for the Waqf board to proceed under the Waqf Act in these circumstances. But I should be given some protection in these circumstances when the Mutawalli himself has gone and approached the civil court. I am
What
saying,
is the stage for interim protection still there or is gone?
yes, my lord, because the show cause notices are all there. Nothing, my lord. My lord has already seen. If they can, my lord, issue a fresh notice against the lessee, they might issue the eviction order against the lessee, which in turn would, my lord, can be construed as my eviction, because if the police goes and gets the lessee out of the property, sub lessee, then, my lord, my possession also goes.
Very well. And what about the citations you exchanged?
Yes, my lord, citations are exchanged. None of the citations cited by the Board of Waqf has any relevance. Let my learned friend place his case. I am heavily relying on Govind Ram's case, which clearly say that, my lord, the tribunal's jurisdiction is very limited. If it's a question beyond the powers of the tribunal, my lord, that cannot be decided by the tribunal. This is a question not relating to Waqf land or not. This is a question of eviction. The amendment to section 83, which brings the question of eviction within the fold of tribunal, is after the civil suit has been filed, much after. So these kind of cases where the civil.
So we are only on the point of whether you can, whether this dispute is covered by section, whichever section.
83. Yes, that's all. If it is not covered by 83, then my respectful submission is no authority has been cited by my learned friends to show that once there is a prior civil suit, that this amendment will take away the right of civil court and, my lord, relegate the matter to the tribunal. Number one. Number two, we have an additional feature where the petitioner, the tenant, is saying that this land is covered by Thika land. So, the Thika Control Acquisition Act 2001 also steps in.
Very well. You file your points by, tell me when.
My lord, my note is ready, my lord, as directed by your.
What about yours?
My lord, admittedly, this is the property of.
No, have you? No, I will not hear any further submissions. Have you filed have you indicated your points?
No, my lord, I have not filed notes.
Tell me by Friday. Friday?
By Friday. Friday, 1 minute, lord.
Lordship may give me a week to file, my lord.
No.
And my lord, it is better, my lord, that we come on affidavits, my lord, because I have not even filed my counter affidavit.
No. Just your notes, please. On the section 82. That's all.
83. On 83, my lord.
On 83. Yes.
I see. Not it will be a little bit tough for me for Friday, my lord. Your lordship may keep it for Monday, my lord. Monday or Tuesday.
Monday. File your points by Monday. Yes.
My lord. Monday, lord.
Yes. A learned counsel appearing for the parties will indicate their short points on the application of section 83 of the Waqf Act 1995, the capital Waqf Act 1995 on 15th May 2023. Stop list this matter on that date.
Obliged.
Grateful, lord.
Next.
Item number 2, Souljo Das versus the State of West Bengal.
I have the state respondents, my lord.
Lordship, Mr. Kajora is appearing on this matter on behalf of the petitioner. Due to personal difficulties, he could not come to court today. So kindly grant not today.
I am for respondent number 8.
Yes, adjournment is prayed. Adjournment is prayed for on behalf of counsel appearing for the petitioner. Stop list this matter on 15 May 2023. Next.
Can I take up after vacation because there's no scope of any interim order? They're asking for refund of money. We say that they are not entitled to. It will take some time, Lord, after vacation.
No. Let the counsel appear.
Fine.
Then if the counsel is agreeable, then fine. If it's personal difficulty, I can't put it after the vacations. Next.
Item number 3, Suresh Kumar Patni and others versus Bank of Baroda.
For the respondent, but I am to make my submissions. Challenge, my lord, in the
I can't hear you.
my lord, in the challenge in these proceedings is to one show cause notice for declaring the petitioners as willful defaulters, and my lord, 2 subsequent notices giving them an opportunity of personal hearing. That is the subject matter of challenge in this writ. 2 grounds have been raised for the challenge. The first ground is that proceedings under section 95 of the Insolvency and Bankruptcy Code has been initiated by one of the creditors of the corporate debtor where they were the directors. Therefore, moratorium under section 96 would be applicable, and that moratorium would exclude all proceedings against the petitioners. That's the first ground of challenge. The second ground of challenge, my lord, is an application was filed under section 66 by the resolution professional to declare certain transactions as fraudulent before the National Company Law Tribunal. That application was rejected. Therefore, since NCLT has rejected an application to declare transactions to be fraudulent, the bank would not be in a position in law to initiate proceedings to declare them as willful defaulters. These are the two rounds of challenge, my lord. My lord, before I address these points, two facts, my lord, if I may indicate. Firstly, my lord, the show cause notice is of 2021.
Yes.
They have challenged November 2021. They have challenged that show cause notice in February 16, 2023. After the show cause notice was issued, they gave a response. I'll just show what their response on merits are. That's just 2 paragraphs, maybe 8 lines, 4 lines each. And my lord, they concluded their reply by asking for a personal hearing. Which facts, my lord, have not perhaps been placed before this
So
court?
this is at the stage of the identification committee?
Yes, identify. My lord's judgment is also there that this is perhaps not amenable to challenge under the writ jurisdiction because no finality is even attached to a decision declaring someone as a willful defaulter by the identification committee. That is subject to the final decision of the outcome of the review committee. Here, my lord, they have challenged at the stage of the show cause notice itself, where they have been given an opportunity to respond within 15 days. They sought for a personal hearing. They were given a personal hearing on 2 occasions. They refused to attend.
How many defaulters are before the court?
My lord, 3.
3. And they are what? Brothers in arms?
They are, my lord, all related parties or relatives, my lord. They're all brothers. Brothers or, my lord, all within the family.
Yes.
If my lord is pleased to take up, my lord, first my show cause notice, which my lord will find at page 37. The addressees are mentioned there.
Yes.
And at page 38, my lord will find the evidence which the bank, the identification committee took into consideration before issuance of the show cause letter. Notice.
So this is under challenge?
This is under challenge, apart from, my lord, 2 subsequent notices granting them personal hearing.
Very good.
If my lord takes up page 40, which is their reply.
So 37 mentions a whole lot of people. Who are these? Who are they? Who are the petitioners? Where
My
are
lord,
the
some
petitioners?
are guarantors, my lord, some are directors.
Very well, but where are the petitioners?
Petitioners, my lord, will see the 3rd entry,
Yes.
4th entry,
Yes.
and my lord, the 7th entry.
These are the 3 petitioners before the court.
Yes, my lord.
No, there's a
My lord, I'll just.
no, not Ankit Jain. He's not before the
Just
court.
a moment, my lord. I'll just check once. No, my Rohit Patni, my lord, would be,
Not here.
my lord, the 4th entry is Rohit Patni. The Ankit Patni is, my lord, right next to the 4th entry, my lord, will see at the middle.
Yes.
4th, my lord, the 2nd column. That is, my lord, the 2nd petitioner before my lord.
Ankit Patni.
Ankit Patni.
Yes.
And my lord, the 3rd row,
Yes.
my lord, the 1st column, Suresh Patni, that's the 1st respondent
Yes.
before my lord.
Very good. Yes.
My lord, at page 40, my lord will find their response.
Yes.
If my lord straight away comes to page 48, if I may first indicate that they had themselves sought for a personal hearing. Page 48, last paragraph, if I may place it.
Yes, I've seen it.
My lord. So they themselves, they do not challenge the show cause notice in 2021. They ask for a personal hearing. They are given the first personal hearing, they do not attend. They are once again given a personal hearing. At that juncture, they approach the writ court.
So they've always been moving around together, all 3 of them. You're also treating them as one, issuing show cause notices, expecting them to come. They've never appeared.
No, separate show cause notices for all.
Yes.
Not one for, the show cause notice is one for all. Personal notices, my lord, are separate. And if my lord sees, my lord, their response, so far as the merits of the case are concerned, If my lord comes to page 45, two paragraphs, paragraph P and paragraph Q, my lord, very succinctly they have stated the response. If I may place it. It would be futile exercise to deal with any such allegations which have been leveled against by you in the show cause notice under reply. Hence, this allegation does not require any further rebuttal or dealing from my clients. I therefore, on behalf of my
From my
clients,
clients, who's writing this letter?
my lord, the advocate for the, my lord.
So show me the first page.
My lord, the
please.
first page, my lord, we'll find at page 40.
Yes,
My lord, this is 20th December 2021.
yes,
And if my lord comes to
yes,
page 45, paragraphs P and paragraph Q,
yes,
there they say, I am not required to deal with any of your allegations.
yes.
That is their response on merits. That about, they have urged 2 points, which points are now, my lord, to be decided. One is, my lord, fraudulent transaction application dismissed. And second, section 96 moratorium.
So this is the letter where they have asked for a personal hearing.
Yes, my lord, page 48, the last page of
Yes.
this letter.
Very well. Yes,
Now, my lord, admittedly, a moratorium under section 96 is in place. The question is, what would be the scope of a moratorium under section 96? And to, my lord, show that, I will also have to place section 14 of the code to show the difference between a moratorium under section 14 and section 96. My lord, section 14 in pith and substance seeks to protect the corporate debtor because the intent is to revive, restructure, rehabilitate the corporate debtor. Therefore, protection of the corporate debtor is paramount. Whereas under section 96, what is sought to be protected is the debt. That is, my lord, by virtue of section 105, because under 105, my lord, the intent is repayment of dues as opposed to restructuring.
yes.
The debtor is not protected. The corpus is protected because repayments are to be made from that corpus. And thereafter, my lord, I will indicate, my lord, the purpose of the notification of the guidelines for declaring a willful defaulter. It has got nothing to do with recovery of debt.
And in this case, there's a moratorium under section 96.
96. Under section 14, there is also my lord's decision, and now there are Supreme Court decisions as well, that it wouldn't protect the director or the guarantor. That legal issue has been put at rest, my lord.
Yes.
Now, my lord, the ploy is section 96. If there is section 95 application pending, if my lord is pleased to take up, if I may hand over my book, my lord. Section 96. My lord is found.
Yes. Yes.
So I may place it, my lord. When an application is filed under section 94 or 95A, an interim moratorium shall commence on the date of the application in relation to all the debts and shall cease to have effect on the date of admission of such application. And
So this application will be is contemplated as application by who?
my lord, any of the creditors.
Any of the creditors.
Creditors of the corporate debtor. In this case, my lord, State Bank of India has admittedly filed an application under section 95.
Yes.
If my lord takes up B,
Yes.
during the interim moratorium period,
Yes.
any legal action or proceeding pending in respect of any debt, my lord, the operative portion becomes debt here, shall be deemed to have been stayed. Subclause 2 provides the creditors of the debtor shall not initiate any legal action or proceeding in respect of any debt.
Yes.
So, my lord, what is sought to be protected here is the debt. And if my lord takes up section 105 once. Section 105, my lord, provides for the repayment plan.
Yes.
The debtor shall prepare in consultation with the resolution professional a repayment plan containing a proposal to the creditors for restructuring of his debt
or affairs. So, my lord, here the intent is a repayment plan.
Yes.
And my lord, as opposed to this, my lord is pleased to take up section 14, because my lord, section 14
Yes.
seeks to protect the corporate debtor. Subject to the provisions of subsections 2 and 3. On the insolvency commencement date, the adjudicating authority shall by order declare moratorium for prohibiting all of the following, namely, the institution of suits or continuation of pending suits or proceedings against the corporate debtor, including execution of any judgment, decree, or order in any court of law, tribunal, arbitration panel, or other authority, transferring, encumbering, alienating, or disposing of by the corporate debtor of any of its assets or any legal right or beneficial interest therein, and so on and so forth. So, my lord, what is really sought to be protected here is the corporate debtor under section 14, because the intent is restructuring of the corporate debtor, failing which liquidation.
So why are you, what is the relevance, Mr. Chatterjee, that in this case, there is a section 96?
In this case, my lord, only
moratorium.
to indicate, my lord, the distinction between the moratorium under section 96.
So you're saying that there's a section 96 moratorium, but not a section 14?
My lord, 14 stage is over.
Very well. So there's a
14 stage
section
in-
96 moratorium
Section 96 is there.
under which the petitioner cannot claim any immunity. That is what you're saying.
Yes, but cannot claim any immunity where the proceedings are not in the nature of recovery of the debt. Because, my lord, what is being protected there is the debt. And the reason why it is being protected is section 105. Because, my lord, unless the corpus is protected, there cannot be an effective or a meaningful resolution repayment plan. So what is precluded by the moratorium under section 96 is any action for recovery of the debt.
Yes.
My lord, there is one decision, my lord, of a
So,
coordinate.
Mr. 1
My
minute,
lord.
please. And you're saying, no, what is the argument of the petitioner that you cannot proceed because of the section 96 moratorium?
Their argument is because of section 96, you cannot proceed against me in any manner.
And that is a part of the lawyer's letter to you.
That is a part of the lawyer's letter to me. That is also part of their submission before my lord.
Yes.
And if I'm before the cite the judgment, my lord, if my lord is pleased to take up
Yes.
the noted RBI guideline.
Please give me the page where they say, where they talk about this immunity.
Yes, my lord. Just a moment. My lord will. Page 47, the last paragraph.
Very good. Yes, that is all. Yes.
If my lord takes up, my lord, the RBI guideline to declare willful defaulters, I need not, my lord has at length delivered judgments, my lord. The intent here is dissemination of information. It may culminate into a criminal action under, I think, clause 3(4). If the bank decides there should be criminal action taken against them under IPC. So, my lord, the intent to declare a willful defaulter is very different. It has got nothing to do with recovery of money. The consequence.
No, what do you do? Normally, you just, it's a name and shame policy, which you follow.
Well, the name is published and that name is circulated, my lord, given to RBI and other bankers so that they are a little vigilant before granting any credit facility to the.
So that is the maximum you go to.
That is
you,
the max.
You can't do anything more than that.
My lord, subsequent to that declaration, my lord, processes may be initiated. It can be a criminal proceeding. After that, but it can also be perhaps a proceeding for recovery of money. But it is a subsequent proceeding.
No, but is that part of the willful default, the master circular?
My lord, yes, 2.6 if my lord takes up. My lord will find that page. No, 2.6. No, my lord,
I don't remember having come across anything like this in the master circular. You can show me the clause.
Just a moment, my lord. My lord comes to page 124. Yes, if my lord comes to page 123 first, penal measures, my lord.
Yes,
My lord, A is no additional facility. My lord, B is what I was saying, my lord, the legal processes, whatever warranted against the borrowers, guarantors, and foreclosure for recovery of dues should be initiated expeditiously.
yes. Where does it talk about criminal proceedings?
Yes, my lord. The next line, my lord, we'll see the lenders may initiate criminal proceedings against willful defaulters wherever necessary. This is subsequently reiterated. If my lord comes to, just a moment, my lord comes to, yeah,
Yes.
page 129. But these are subsequent
Very well.
proceedings.
Yes, yes.
129, my lord.
Yes. So, very well, Mr. Chatterjee, anything else?
Yes, my lord. My lord, there are two judgments, decisions, one of a coordinate bench, my lord, on the aspect of section 95 moratorium and willful defaulter. This court has been pleased to hold that it wouldn't really preclude banks from initiating proceedings under this circular. Judgment again? No, wait, no. Just a moment, my lord. Wait. আমার এখানে mark করা আছে।
Yes.
My lord, this decision, my lord, paragraphs, paragraph, এটা copy দিয়ে দাও না একটু। My lord, paragraph 7, my lord, this paragraph 4 would indicate what the issue was before the court. Thereafter, my lord, the submissions are recorded of the parties. Paragraph 11 onwards would be relevant, my lord. Paragraph 11, 12, 13, 14, 15, 16, and 18, if I may place them, my lord.
No, just tell me the point, that is all.
So, my lord, the point here is, my lord, what I have submitted that section 96 only precludes proceedings for recovery of debt. It would not disentitle a banker from initiating action, my lord, for declaring a defaulter as a willful defaulter under the RBI guidelines. One of the relevant paragraphs would be 11, 12, 13, 14, 15, 16, and 18.
Yes.
And my lord, following this, there is also a decision of the Madras High Court. Madras judgment.
Yes.
Madras judgment. Which citation নেই দাদা, এটা তোমার printed copy.
Yes.
Just a moment. Here, my lord, paragraph 6 onwards, my lord. Same issue.
No, this is Ahmedabad, Gujarat High Court.
Gujarat High Court. I'm so sorry, not Madras. I'm so sorry. I'm so sorry. Stand corrected, my lord.
Yes.
Gujarat High Court, my lord. Paragraph 6 onwards. আমাকে একটা copy দিন আবার।
No, just tell me the point, please. I will read it.
Same issue. Same issue.
That 96 will not protect proceedings under the willful defaulter, the
My
master
lord, my
circular.
lord, my lord.
That is the point.
Yes, my lord. And the decision of our coordinate bench has also been, my lord, taken note of and followed.
Very well. Which page is that?
My lord, starts from paragraph 6. And my lord will find the reference to our case at page, my lord, internal page 17, paragraph 10.
Yes. Yes.
My lord, that apart, they have taken a point
Yes.
that the application, my lord, to declare the transaction to be fraudulent.
Yes.
has been dismissed, my lord. Now, first thing, my lord, I am not a party to that proceeding. The bank is not a party.
Yes.
It is between the resolution professional and the respondents. That wouldn't, in the first place, be binding on me. Secondly, my lord, once again, I have indicated the nature and scope of the circular. And my lord, if I may only indicate section 66.
Yes. Mr. Chatterjee, another 2 minutes, please conclude.
My lord, I'll try
Section 66.
My lord, section 66. My lord will see in under section 66, two conditions must be fulfilled.
Yes.
One, the transaction is fraudulent, and the other, it is intended to defraud the creditors. Whereas, my lord, to declare somebody as a willful defaulter, these are not even the conditions which need to be satisfied. My lord, the conditions which are required to be satisfied, my lord, are delineated, my lord, in clause 2.1.3 of the circular at page 120.
Yes.
Therefore, the guiding factor under section 66 and willful defaulter, they are at variance. And secondly, my lord, there is a separate circular of RBI for the purpose of declaring someone as a for declaring a transaction to be fraudulent. It is not even covered by this, my lord, circular.
Yes.
My lord, if I may only place that circular, my lord, I will not trouble my lord with the details of it. Circular to them. I will not trouble my lord with the details of it. I'm the cheetah. My lord, this is a master direction on frauds, classification and reporting by commercial banks and select financial
It is
institutions.
relevant to place,
But
otherwise.
in the sense, relevant in the sense, my lord, only to show
Yes.
that the issue of fraudulent transaction, which section 66 is concerned with, is not even the subject matter of a circular under for declaring willful defaulter. There is a completely different circular issued by RBI in the year 2016 for that purpose.
Which paragraph?
If my lord is pleased to take up. My lord, first 1.3 and thereafter, my lord, 2.2. 1.3 is the purpose and 2.2 provides for classification of frauds.
Very well. That is all, Mr. Chatterjee?
That is all. And my lord, I need not cite, my lord, those judgments, my lord, where a show cause notice is really not amenable to challenge, especially when a right is not infringed. My lord's decision is there, my lord. It covers all the issues. Even if I fail to give any cogent reason for the purpose of issuance of my show cause notice, my lord has held that I am not required to give reasons. Even, my lord, I need not perhaps embark on those lines.
No, but I presume you're saying need not because you think the court remembers. That is a presumption.
And that was my lord.
Yes.
Presumption, if my lord wants, I can place it, but I am my lord's decision, my lord, in
No,
Sanjeev
you can
Kumar.
place some other decision, not this court's, please.
Very well, my lord. That is relying on the division. I need not go there, my lord.
Very
I need not
yes.
venture.
Learned counsel appearing for the respondent bank has concluded his submissions. Stop. Yes, Mr. Ghosh, when do you want to come back?
My lord, day after tomorrow.
List this matter on respondent Bank of Baroda. List this matter on 12th May 2023 for hearing the petitioner. Yes, next.
I'm grateful, my lord.
Item number 4, Kanchan Dotto versus the State of West Bengal.
Hearing for the petitioner.
I'm a state, my lord.
Have you finished? Did you
Lordship.
conclude last time?
Lordship, the state was directed to come up with the instruction with respect to, Lordship, these were deeds which were presented for registration.
Yes, yes.
And there was some technical difficulty because of which it could not fall through.
Lord,
Lordship,
this is my instruction, Lord, just seeking some more time because what happened, my lord, when the original deeds are presented, the query sheets in respect of 2 were, so the errors had to be rectified. While rectifying, my lord, there was a change in, my lord, the specification of the modules and they became in the separate special project. There's a technical defect, my lord. They will get it, but
Have you given a copy to your learned friend?
no, my lord.
Yes, এটা একটু দাও তো ওনাকে।
না, copy করে দিচ্ছি, করে দিচ্ছি।
রংটা তো কারেক্ট করে নিবো।
You can take a snapshot of that.
হ্যাঁ, একটা ছবিটা তুলে
I'll give a copy. I'll give a copy to everybody, my lord. আচ্ছা, আচ্ছা।
ছবিটা তো
Copy করিয়ে দিচ্ছি না।
Just দেখতে দাও।
Actually, in respect to this, the correction needs to be done definitely. But now that the project, the module has been declared as special project, the module has been declared as special project. The property subject matter of the deeds have been declared as special project. 2 deeds have already gone through, the registration is complete. But in respect to 2 other deeds, there were certain mistakes in the number of the floor. That can be corrected. Thereafter, as far as the recordings, Lordship, this appears to be that the project has been declared as a special project. That's why this difficulty is there. Now, this is a computerized system. This, my learned friend can instruct his client to do it manually, then this can...
But possibly manually cannot be done, my lord. We are trying to, my lord, get it done through NIC, who maintain the, my lord, computer system, my lord. Some time is required. Nobody's fault, my lord. They are entitled to get it, my lord, because of the, my lord,
No, what
computer
is
system.
some time? How much time do you want?
No, I'm praying for 4 weeks time, my lord. Because of
You not get that. You better do it in 2 weeks. 2 weeks.
2 weeks.
Actually, it can be done in this side of the vacation because the registration fees has been paid. Now, if
But
the
everything-
project has been declared special project, there will be a difference in the stamp duty. Then I'm entitled to a refund.
My lord,
No, I do not know whether my learned friend
That is not correct, my lord. Since they have presented the document, my lord, the date of execution, same stamp duty will, my lord, prevail. No
Lordship,
additional
let
fees
it
to be paid.
Let my learned friend, let it be completed before the
We
vacation.
shall try as early as
Very
possible.
well. Learned counsel appearing for the registrar of assurances.
2 and 3. no?
Hands up the instructions. Hands up a copy of the written instructions dated 10/5/2023, which admits that the queries with regard to the wrong floor number being entered in the deeds could not be corrected despite several attempts. Stop. And that the case has already been referred to the registrar of assurances by an office memo dated 17/9/2022.
E-assessment.
The concerned respondent proposes to forward
Assessment slip-এর কথাই বলেছে।
the same memo once again to the registrar of assurances on 30/1/2023. As well as forwarding the E-assessment slips on 3/5/2023 for necessary action. Stop. Council submits, council submits that the respondents need some more time to
Correction করে date টা দেওয়া আছে।
correct the entries in the deeds.
Lordship, may I interrupt?
In
There
the-
is no mistake in the deed. It's only the E-assessment. slip.
Requires some more time, some more time for rectification of the defect in the E-assessment slips of the modules mentioned in the writ petition. Stop. Should I keep the writ petition pending or dispose it off?
Lordship, let it be pending, Lordship, let us
List this matter on 18th May 2023 for the,
Is it possible to take up on reopening day? If it is not possible, then again I'll have to ask for extension kindly.
no, do it by
We
18th.
shall do it. We shall do it.
For the respondent number
2 and 3.
2 to make, to take requisite 2 or somebody,
2 and 3.
respondent numbers 2 and 3 to take requisite steps in the matter. Stop. Since the entire matter was was forwarded to the Registrar of Assurances on 17/9/2022, as per the instructions, it is expected that the concerned respondents shall not ask for further extension to do the needful. Stop.
Just now, your lordship was kind enough to observe 2 weeks time shall be granted. If 2 weeks is granted, my lord, we shall do it and
2 weeks will
communicate
take
to
us
them.
beyond
We
the
shall communicate
vacation.
to them within 2 weeks. I know, my lord, we shall
No,
communicate to
2
them.
weeks will take us beyond the vacation. Do it this time.
I'll-
Great.
we
Yes,
shall-
follow next.
Much obliged.
Lordship has recorded that
Item
the mistakes are in the e-assessment slips, not in the deeds.
Item number 5, Mrs. Gatik Tea and Co. Private Limited versus Bank of Baroda.
That money being given to somebody else. That's the matter.
Collateral security being given to someone else.
Title deeds. The
Yes.
title deeds.
The title deeds. Look, there would be a color of a private dispute. There would be another issue which I will have to address, your lordship, but the facts are company,
So you're saying private dispute, or they will take the point?
they will take the point of private dispute. And I'll indicate, because first blush, even I thought private dispute.
Yes.
I take a loan from a bank.
Yes.
My ex-director, because then there's a share purchase agreement by which then new management that comes in. My ex-director gives a personal loan. Shown of all details, this loan is transferred to another bank. The respondent bank here writes to me that without a board resolution, this particular guarantee that is being held of your director, who's a private respondent here, cannot be given. There are disputes between the company
Yes.
and the private respondent.
Yes.
I lodge an FIR that he's taken away 50 lakhs of my money. The private respondent also lodges an FIR against me. Both parallelly proceed. In the section 91, in the investigation pertaining to the complaint lodged by the private respondent, a section 91 notice is issued by the police upon the State Bank of India, asking the State Bank to hand over the original title deeds, Bank of Baroda, the original title deeds to the private respondent.
Yes.
This issue is under challenge here. Look,
Yes.
when we got to know of this information, we had come up before this honorable court. Before we could actually, after filing, but before we could move, the bank had gone ahead and returned the documents to the private respondent. I will seek to address your lordship only on one count. First, that there is no private dispute here. My only issue that I want to urge before your lordship.
No, have they taken that point? No.
On the first round litigation, it was happening, they've taken the point. Here also they will take, and ostensibly justifiably. But I'll tell you, lordship, the issue on which I want to address this court on. One is under section 91. In course of an investigation, the police authority has no jurisdiction to direct for documents to be handed over, not to him, but to the de facto complainant.
I remember that point. Yes.
If that jurisdiction is not there, then all steps which are a corollary to an order passed without jurisdiction is wrong. So, irrespective of whether this is a private dispute, whether the loan stands transferred to another bank.
1 minute. What was Ms. Chakraborty's point?
Her point was that the loan stands transferred on my behest. The
Yes.
bank can't withhold